Hello, am I audible?
My lord, may I have the liberty to make a mention, my lord? My lord.
My lord, we can't hear your lordship, my lord. I think it's mute.
My lord, perhaps
But the court
the speaker
audio is
switched
mute,
off.
my lord. We can't hear your lordship, my lord.
The speaker is on mute, my lord. Yes, my lord. Now it is unmuted. My lord, may I make a mention regarding the WPA 615 of 2024? And in this, my lord, on the last date of listing, the Honorable Court had passed the orders on 9th April 2024, giving the opposition opportunity to file their affidavit by 30th April. My lord, unfortunately, they have not filed. There is nothing on record that they have filed, whether it is the official respondents or the private respondent. The official respondent in this are, my lord, the Union of India and the authorities in Bengaluru in Siliguri, my lord. So, my lord, my request is that since the opposition, they are not interested in filing any affidavit in opposition, I may this case may kindly be listed for final hearing in the coming week, my lord. We have already served the notice.
My lord, we can't hear your lordship, my lord. I think there's some audio problem, my lord. I don't think my learned friend also can hear your lordship.
I can't hear.
My lord, the audio we can't. I think nobody can hear your lordship, my lord.
Yes, can you hear?
Yes, my lord.
Now, my lord, it's clear. Absolutely.
What is the matter? What is the matter?
Matter is, my lord, my client is a lady doctor and she's a specialist in dentistry, my lord, and she was employed by the respondents on terms which are contained in a policy which is issued by the Union of India. Ignoring that policy, the respondents 3 and 4 here in Bengaluru, they have thrown her out, and I'm a specialist in my place.
Okay. Any of your junior is here?
Yes, my lord, she is there.
You have given the list already. Yes, your junior is given the list. I will go through and it will be listed. It will be.
I'm grateful, my lord.
May we have your lordship's kind leave?
Mr. Bhattacharya?
Mobilize, my lord. My learned friend had mentioned this matter yesterday, my lord. This is a matter of critical importance, where, my lord, non-bailable warrants were issued against the directors of a company, my lord, for termination of a lease in a 420 proceeding. My lord's pleasure was that we will file it tomorrow. Yesterday, my lord, we should have filed it yesterday. It will be taken up tomorrow, my lord. It's on Friday. My lord, we will go and we will attend the court physically. My lord, we could not file yesterday because the authorized person came from Odisha yesterday only, my lord. We are filing today in the first half. If it can be taken up tomorrow, my lord, whenever it's convenient. Tonight we are reaching Jalpaiguri, my lord. We will address your lordship physically.
So what you have prayed for?
Quashment of the proceeding, my lord. For termination of lease is a 420 proceeding, your lordship understands. against all the directors of a company. My lord, the AOR is in court, my lord. He will hand over the slip, my lord, after filing. If may be taken up any time tomorrow, my lord, I will do physically.
Tomorrow is the Friday, no? When the criminal matter will be taken. What is the urgency? Warrant is being issued.
No available warrants issued, my lord, on Monday, my lord. That's the difficulty. We got the certified copy day before we prepared it, my lord, we are filing. My lord, in other circumstance, ordinary circumstance, I would not have requested your lordship.
Oh,
So, my lord, it can be taken up any time tomorrow, my lord.
fixed tomorrow as especially fixed matter.
Most obliged, my lord. Most obliged.
My lord, may I be permitted
My
to
lord.
mention one matter for including the list, my lord? My lord, this is a criminal revision matter. This is CRR 37.
I can't hear you, sir.
My lord, am I audible, my lord?
Yes, yes.
My lord, may I be permitted, my lord, to mention one criminal revision matter? It is CRR 37 of 2024, my lord. Actually, my lord, this matter listed before Honorable Justice Bibhash Ranjan Day on 13th February, and his lordship was pleased to admit the matter, and also granted interim protection to the petitioner, and also fixed the matter to appear in the next circuit bench. My lord, I am praying for inclusion in the list, my lord.
You're given the list.
Yes, my clerk is there. He's giving the list. He's giving.
Who is
the
your
list, my
advocate
lord.
on record here?
I am advocate on record, my lord.
So where is your list?
My clerk
Where
is
is the
there.
mentioning list?
My clerk is there, my lord. He is giving.
You send the mentioning list to my court officer, it will be listed.
My
Deeply
lord,
obliged, deeply obliged.
my lord, may I be permitted to mention one matter for upgradation in the list? My lord, this matter has been mentioned day before yesterday. Today it is running in as item number 61 in today's list.
Hmm.
So my lord, kindly fixes a date. Fix this matter anytime tomorrow or today, as your lordship may please.
What is the urgency? 60?
My lord, the urgency is that the dispute is in relation to church, the
Item number,
administration of church.
item number?
Item number 61. Item number 61. My lord, yesterday it was appearing as item number 30 and today 61.
Yeah.
This is for admission of an added party.
Just a
Addition
minute.
of a party.
When the writ Monday? When the writ will be listed? Writ. No. How it can be 22?
My lord,
Then 21st is there? Tomorrow what is the tomorrow?
Vishwarupta, your
Then
audio
what
is.
I am telling you.
I mute your audio.
Tomorrow is the writ matters, no? It will be tomorrow. It will be listed, madam. Tomorrow it will be because writ matter will be taken tomorrow. So application will come over.
my lord, I
My lord,
am
kindly
mentioning.
discuss it in
My lord, I am
the
seeking your.
leave matters as a fixed matter.
Yes, Mr. Bhattacharya.
My lord, I am extremely sorry, my lord. I tender unqualified apology, my lord. Yesterday, my charge got over, my lord. I could not connect. My lord, item number 79 of the day's list, my lord, my instructing advocate is there.
Yes.
My lord, could it be taken up any time during the day, my lord? I will be praying for a short, my lord, protection from your lordship, my lord. Despite your lordship's court's previous order, my lord, they are conducting an inspection today without disclosing me papers. They served me a notice yesterday. Yesterday, they served me a notice. My lord, Mrs. Ghosh is there, my lord. My lord, she is handing over to your lordship, my lord. May the matter be taken up any time during the day, my lord, subject to your lordship's gracious convenience.
So this is the demarcation. So what will happen after the demarcation? They will not take the
My lord,
post.
this is a kindly sees, my lord, it is a section 57 Land Reforms Act proceedings. My lord, I am agreeable. My lord, I am supposed to adduce evidence. What I was, my lord, humbly beseeching your lordship, my lord, I told your lordship to kindly keep it on Wednesday next. My lord, subject to your lordship's gracious convenience, your lordship also agreed. My lord, till Wednesday, nothing is to be done, my lord. That is the only thing.
So
Because there was a.
So today is fixed for demarcation, I think so.
My lord, that demarcation order, my lord, has already been carried out. Today, my lord, apropos, my lord, kindly sees there is a reference of an April, my lord, decision of the Heritage Commission, which has not been disclosed to me. I do not even know. My lord, kindly sees.
Who is for the state? Who is for the state?
My lord, Mr. Subir Saha is appearing for the state.
He is not appearing. Yesterday also the same thing. We have called that he has not appeared before this court.
My lord, what I was, I'll put them on notice, my lord, may the matter, my lord.
come up, my lord, at any time convenient to your lordship's court today.
Okay, come at 3 p.m. You come at 3 p.m. We'll see to that.
My lord, 3 p.m.
Item number 79. 79.
Yes, my lord, 79.
Item number
3 p.m.
79, 2 p.m. 3 p.m. no?
I'm grateful to your lordship, my lord, grateful.
With the kind permission of your lordship. Lordship, these are the...
Give the notice to the other state. Give the notice to the state.
Yes, Mrs. Ghosh is going to do the needful, my lord. Mrs. Ghosh is going to do the needful.
Lordship, these are the two matters out of a same company. Two separate proceeding notice has already been issued. All the proceedings has been complied with. Affidavit has been served. Lordship, if the matters will be taken
Give the
up,
list to me.
I'm grateful. Dada.
CRR has appeared on the month of February. The respondents were directed to file affidavit in opposition, but till date they did not file.
CRR affidavit opposition.
Yes, your lordship. On the last occasion.
What is the matter on the CRR?
Lordship, this is simply a civil dispute and has been given the color of criminality. The petitioners are the directors of a company. They have to travel all the way from Karnataka to for the lower court for lower court.
So what do you want?
Lordship, I'm praying for quashing of the FI, your lordship.
So give the list, it will be listed.
Lordship, I have mentioned this matter since Tuesday, your lordship.
But might be you not mention, you are not mention the urgency.
Yes, sir, I have mentioned
You
the
mentioned
urgency.
the
I have
urgency,
served the opposite sides also, your lordship.
If you mention the urgency, it will be listed.
Yes, your lordship.
Okay, whatever the demarcation, that will be abide by the result. I will see what is. Let it come at 3 p.m. Let they come. I will take the matter. If anything you bring, I will see to that.
Lordship, at present, I'm praying for if they do not file the affidavit in opposition, then kindly I'm praying for a stay because they have to travel all the way from Karnataka for the hearing in the lower court, your lordship.
Give your list.
Yes, I have submitted, your lordship. I have submitted, and this is one more copy.
My lord.
Okay, I will see to that.
Grateful, your lordship.
Yes.
Deeply obliged.
My lord.
What is your prayer in the writ application?
Against the WPS, it says state government enterprise. The company has carried out a transmission project on my land.
Now, what is your prayer in the writ petition, sir?
Prayer is comprehensive investigation against the serious and
When the direction was passed for affidavit? When the direction, is there in direction for filing affidavit?
It was on March 24.
How much time? Okay, where is your mentioning list? Give the mentioning list to my court officer, it will be listed.
My lord, may I permit to mention one matter, my lord? My junior Mr. Orijit is before your lordship, my lord. My lord, one matter, my lord, this is a municipality matter, my lord. On the last occasion, matter was heard before Honorable Justice Raja Basu Chaudhary, my lord. Lordship was directed the municipality to provide a report as they are wrongfully encroaching my land, my lord, and they're illegally being construction, my lord. If any day, my lord, allows the matter to be heard, my lord, it's a very short point, my lord. If any, my lord.
Give the mentioning list, it will be listed. Give the mentioning list. Where is your mentioning list? Give the mentioning list. Yes, call the list.
Grateful, my lord. Grateful, my lord.
Which order?
Order dated on 2nd of May. First portion of the order is number 25. Last portion of the order 26, right?
GR case number?
25 is the right. Yes.
Is that correct?
Correct.
On the first page is correct.
Correct.
Where is the another number? GR 27. That is only. It should be 25. So and so appearing for the petitioner. The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. This court, by an order dated 2nd May 2024, has disposed of CRR number 123 of 2023. Counsel for the petitioner submit that in page number 2, paragraph 2, line number 2, the GR case number has been inadvertently recorded as 27 of 2017 instead of GR case number 25 2017. Consider the submission made by the counsel for the petitioner. In the order dated 2nd May 2024, in the second page, second paragraph, second line, the GR case number shall be read as 20. GR case shall be read as 27 of 25 of 2017 instead of 27 of 2017. This order may be incorporated, shall be read along with the order dated 2nd May 2024.
Well, we are appearing on behalf of the petitioner.
Yes.
Mr. Neelaj Chakraborty is appearing on behalf of the state, I presume.
Huh? Huh? Where is the report? Pass over. Huh? At 11:15. Yes.
My lord, I am appearing for the petitioner in this matter. Am I audible? I'm for
Yes,
the
who's for the
petitioner in this
petitioner?
matter. I'm appearing for the petitioner, my lord. Am I audible? My lord, am I audible?
Yes.
My lord, I'm for the petitioner. In this matter, we had been directed to file a supplementary affidavit
Yes.
bringing the current state of the case before the court.
Correct.
That affidavit is almost ready. I understand that the advocate on record will file it soon. So may I pray for a short pass over, my lord?
Pass over.
Most grateful.
Item number 4 at 2 p.m. Item number 4 at 2 p.m. Item number 4 and 5 at 2 p.m. Call the 6.
My apology. For since Mr. Clerical is on the he is arguing the matter item number 13 is running.
Who is for the petitioner?
I'm for the petitioner, Your Lordship.
Yes.
This matter, Your Lordship, the extension petition has already been disposed of by an order dated 24/4/2024, Your Lordship. The matter is ready for hearing and we are also prepared for the hearing, Your Lordship.
Grant 4 is already disposed of.
Yes, Your Lordship. By an order dated 24th April 2024, Your Lordship.
Yes, it is correct.
Oh, we are ready. We are ready for the let the matter discuss tomorrow.
So and so appearing for the petitioner. So and so appearing for the respondent. Estate. You are for the estate. For the opposite party number 2. Full stop. Party number 2. Counsel for the petitioner submit that. No, estate kori. Counsel for the petitioner submit that. By an order dated 24/4/2024, this court has already disposed of CRAN 4 of 2024 by extending the interim order. Full stop. Consider the submission made by the counsel for the petitioner for use the order dated 24/4/2024. It is found that this court has already disposed of CRAN number 4 of 2024. Accordingly, department is directed to delete the CRAN number 4 of 2024 from the cause list. Yes.
Your Lordship, it can be taken up tomorrow for hearing.
Let
For final, we are also ready, Your Lordship.
let CRR number 241
241, Your
of
Lordship.
2023 be placed when the criminal matter will be listed. %.
Your Lordship.
Yes, next. Next.
But I am for the petition. This appeal against not acquittal or for admission, there is a delay of 200
Who has filed this appeal?
one of the de facto complainant.
De facto complainant.
Only for admission.
Who has signed this appeal?
The Parthopati Mishra.
Where?
But his father is seriously ill.
No. When it was how it has been listed? CRA.
Here.
Where is the affidavit? Where is the punching? Where is the stamp? How it has been listed, admitted? Who is in the filing section? Who is in the filing section? Call the registrar. Send the person to call the registrar. Pass over. For the next matter.
Thing number 8. This is for one correction matter. The name of the appellant is wrongly recorded as Bablu.
In the order.
In the order.
What is the actual name?
W, my lord.
W.
W.
The matter is listed as so appearing for the petitioner. Petitioner or appellant?
Appellant.
Appellant. Full stuff. Counsel for the petition submitted in the order dated 26th April 2024. The name of the appellant is inadvertently recorded as Bablu, Bablu Chaudhary, alias Mia, MIAH Mia, instead of WDABLU Chaudhary alias Mia. Consider the submission made by the counsel for the petition, peruse the record. In the order dated 26th April 2024, the name of the appellant shall be read as WDABLU Chaudhary alias Mia instead of Bablu Chaudhary alias Mia. Next.
Your Lordship, kindly pass over the matter.
Yes.
Kindly pass over the matter.
Pass over. Who is for the petition?
I am for the petition.
Yes.
And I'm praying for quashing of the proceeding, being Bhaktinagar Police Station case number 315 of 2024. If you also kindly seize the FIR, madam, which is at page 19. It starts from 20, madam.
Page
20, madam.
Yes.
Madam, may I read, madam?
No.
But in the first paragraph, he has tried to explain that there was an agreement with the landowner, wherein the consideration sum was fixed at 18 lakhs and 3 lakhs has been paid, madam. In the second paragraph, if also kindly comes, whereas it is pertinent to mention here that Dr. Manas Kumar Das, he is allegedly the landowner, later on permitted Mr. Dilip Sharma, who is willing to purchase, to enjoy the vacant possession of the said land, and also permitted him to use the said land until he resolves his issues and transfer the said land to Mr. Dilip Sharma. So far, the possession of the said vacant land was being enjoyed by Mr. Dilip Sharma without any hindrance. However, till day before yesterday, is at the time of departure from the school, the said land was in its initial state, but the very next day in the morning, I saw that the said land was bound by temporary tins from two sides of the said land, and the front side of the said land was completely blocked. I informed the matter to the chairman, Mr. Dilip Sharma, and he told me to wait for a while. In the meantime, he shall inquire the matter with Dr. Manas Kumar Das regarding the said tin boundary. However, he was informed by Dr. Manas Kumar Das that he had no knowledge about the matter.
Just a minute.
Yes, ma'am.
Who is affirming? Who is taking affirming? Who is the oath commissioner?
I'm one of the.
And who is taking? Who is registering the all files?
Sure.
Yes. You come. Okay, no problem. You come here. How this appeal has been given number? Where is the stamp? Where is the oath signature of the appellant? Where is the signature of the appellant? Where is stamp? Where is the signature of the appellant? Where is the oath commissioner? If it is appeal, how you admitted with the facts? It is the format of the appeal, criminal appeal.
Generally, may not, in case of appeal, the commissioners do not take it.
So how you have registered? This is the format of appeal.
Oh no.
This is the format of appeal. Facts have been narrated. So
No certified copy of the.
no certified copy is there. Appeal in the criminal appeal, in the civil appeal, only the grounds and certificate. That's why this oath commissioner cannot affirm. If it is continuation of oath, so it has become an application. And you have registered an appeal. How it can be? You have registered this, and this practice is going on, advocates are filing, you are taking all these things. How will you have to go by the appellate side rules? Please, henceforth it should not be. Yes.
Yeah, the last paragraph. In the first, second paragraph, he says that suddenly, no, this Passover. Suddenly on 9th, he came to know that he found that there was a the land was bounded by teens, Malad. I informed the matter to the chairman, Mr. Dilip Sharma, and he told me that to wait for a while. In the meantime, he shall inquire the matter with Dr. Manas Kumar Das regarding the said teen boundary. However, he was informed by Dr. Manas Kumar Das that he had no knowledge about the matter. Dr. Manas Kumar Das had no knowledge. After getting in touch with some local people, I got to know that one Vikas Lama, the petitioner hearing, owner of second-hand vehicle showroom situated south to the scheduled land, and his muscleman and an antisocial associate Sunny and other miscreants had erected the temporary teen boundary without the knowledge of the parties interested to the scheduled land. I pause here for a moment. This FIR was lodged on 9 April 2024. Now, this Manas Kumar Das has also issued a suit against me. Kindly see the criminal conspiracy between this proposed purchaser and the seller. Page 36. This is the copy of the plaintiff, filed by Dr. Manas Kumar Das.
Yes.
And it has been filed on.
Who is the accused in the matter?
Accused Vikas Lama. He is also involved in this suit, Madam. He has also been implicated in the suit also.
Vikas Lama.
Yes, Madam.
Yes.
Malad, kindly sees.
What is the section? 448, 323, 506.
Yes, Malad. Malad, kindly sees, Malad. Page, this plate starts from 36 and 41 is the verification. On 8 April 2024, it was verified.
8th April?
8 April.
Yes.
9th April, complaint was registered by the proposed purchaser, agent of the proposed purchaser.
Yes.
And the seller issued the suit on 8 April. Yes. Now, if you kindly see the abandonment, page 38, paragraph 6.
Yes.
That the plaintiff has been paying revenue to the government of West Bengal in respect of his land being its true owner.
Yes.
He immediately after purchase surrounded the suit land by plinth level concrete boundary. Subsequently, the plaintiff has raised boundary made of CI sheets in tin boundary. The plaintiff thus has been possessing, occupying and enjoying the suit land.
Who is for the estate? Have you issued notice?
No, motion stage. New motion. Kindly seize the conspiracy. They are after my land. They now require my land also. They are actually land mafias.
The petitioner has filed the present application under section 482 of the Code of Criminal Procedure, praying for quashing of the proceeding, being GR case number 1702 of 2024, arising out of Bhakti Nagar Police Station case number 315/2024, dated 9th April 2024, under section 448, 323, 506, 379, 34 of the IPC, pending before the London Court of Chief Judicial Magistrate, Jalpaiguri, Police Station. The complainant, the defective complainant, had initially filed its suit, being title suit number 234 of 2020.
Defective complainant has not filed this suit.
No.
He has lost the
Purchase.
complaint.
Purchase. The one Dr. Manas Kumar Das, one Dr. Manas Kumar Das had filed a suit, being title suit number 234 of 2024, against Mr. Vikas Lama, Keso Mangarati, this one, Gita Urti, So, page number 36. 1, 2. For declaration, injunction, and other consequential reliefs with respect of the schedule of property, which are as follows. Page 41. Sri Surendra Thakur had initiated an FIR on 9th April 2024 at Bhakti Nagar Police Station against the petitioner
And
others on the same self-land, on the same self-cause of action, making an allegation with regard to the trespass of the land and using filthy languages and muscle powers. On the basis of the complaint, the police has registered the above. This court find that the dispute between the parties are purely civil in nature, only to take the shelter of criminal case, only to take the benefit from the police authority. The complainant has initiated a criminal case against the petitioner. In spite of having knowledge that Dr. Manas Kumar Das had already initiated a civil suit before the learned of Civil Justice Senior Division at Jalpaiguri. Junior Division at Jalpaiguri. Consider the above circumstances, this court find that this is the fit case to stay the criminal proceedings initiated by the police, being Bhakti Nagar Police, being FIR number 315 of 2024, dated 9th April 2024, under section 448, 323, 506, 379, /34 of the IPC, until further order. The petitioner is directed to serve notice upon the state, list the matter before the next circuit bench.
If you also notes one line, in the suit, they have said, the Manas Kumar Das is saying that I am in possession of the land, I have made the boundary.
That's a civil dispute. Why do you want to take all these things? It's a civil dispute.
Yes,
you take in the defense.
Grateful, Lord.
Next. Next. Which is number?
Grateful.
Who is for the petitioner? Pass over.
Item number 13. Lordship, I'm paying for 1-day accommodation.
Huh?
I'm paying for 1-day accommodation.
Why?
Lordship, the learned advocate on record is out of station because of father's treatment.
Let the matter appear on 21st.
Carefully, Your Lordship.
Next.
Item number 13. The Lordship for the state and seeking a person.
Lordship.
Who is for the petitioner?
Lordship, I am for the petitioner. Lordship,
Yes.
in this matter, Lordship, this is the matter is relates to release of vehicle, which was apprehended under the NDPS Act. Lordship, in the matter, on 12th of October 2022, petitioner through his driver get a phone call from one person, namely Hemanto, which photograph
Why
is
you're not
annexed in the.
Why you not made an application before the trial court?
Lordship, I'm coming to that. Lordship, kindly have a look on the order passed by this honorable court earlier. That is page 21, 22. In terms of that order, Lordship, twice I had been to the learned trial court, before the learned trial court, and on the 13th of October 2023 and thereafter 24/11. I have annexed the copy of the application which was sweared by the petitioner. But it is most unfortunate that on 13th of October, learned judge told the learned advocate on record that let you come after puja vacation. And when after puja vacation he had been to the state court, then learned judge says that I am otherwise busy, I will not take up the matter today. So the reason that petitioner come before your lordship. I have annexed the petition copy and everything, lordship.
Where it is? Where is
Lordship,
the application filed before the?
Page
Where is
23, 20.
Where is your
Lordship.
application filed before the learned trial judge?
Lordship. Annexure D, page 23 to 37.
When you have filed? When you have filed this application?
On 13th of October, first I have mentioned it with this put up petition, and learned just told the learned advocate on record that let you come back after the ensuing puja vacation. After puja vacation, in the month of November, that is on 24th November, petitioner again had been to the court, learned court, and again refused.
Where it is?
And there is an order by this honorable court, lordship, that is the page 21-22, in the earlier writ petition regarding quashing of the proceedings against the petitioner, the owner of the vehicle. The Honorable Justice Rajashekar Mantha has been pleased to pass an order directing to go before the trial court, and I have annexed that record. In spite of that, it is not taken up. So, lordship, what is my humble prayer at this stage, lordship? Lordship,
Appearing for the petitioner. You are for the state. Yes, what has happened to the put up application before the court below? Which you have filed? So appearing for the petitioner, so for the state. Full stop. Initially, the petitioner has filed an application before this court, being WPA number 2936 of 2022, praying for release of the truck, release of the vehicle. But by an order dated 22/11/2022, this court has disposed of the said application by giving the liberty to the petitioner to make appropriate application before the trial court. Before the trial court. Full stop. Counsel for the petitioner submit that the learned trial, the petitioner, and after the order dated 22nd November 2022, the petitioner has filed a put up application before the learned special court under NDPS Act, First Court Jalpaiguri, by way of a put up application, praying for release of the vehicle, but the learned court has not disposed of the said application, and the said application is still pending.
No, lordship, the application is returned to the petitioner. It was not taken by the learned court.
So what has happened on the put up application returned to you?
Returned to me.
Yeah, has filed an application
for release of
the vehicle by way of put up application on 13th October 2023. 13th April 2023. 13th, 13 October 2020. 13th October.
13th October, lordship.
But the learned court refused to take the application and directed the petitioner to come after the puja vacation. Yes. Then what has happened?
And thereafter, again on 24th November 2023, petitioner had been to the learned court and again refused.
As per the direction of the learned court, the petitioner has again filed an application on 24th of November.
November.
Where is your application 24th November?
Lordship, this application, since it is returned, it is squared already, so the
Again.
similar application.
Again, on 24th of November 2024, the learned counsel for the petition approached the learned trial judge. So what has happened?
It was not taken by the learned
judge
court, Lordship.
Has not taken the said application on record.
But these are all, my lord, one.
That's I am taking. If it is wrong, I will send his name to the bar council. If the judge has taken this, I will take the appropriate steps. Full stop. The petitioner has made a severe allegation against the judge, as the judge is not taking the application in spite of taking the application for release of the vehicle, and as such, the special judge under NDPS court, first court Jalpaiguri, is directed to submit the report whether at any point of time the petitioner has made any put-up application for release of the vehicle. If it is made and the court has refused to release, to take the application, to explain why the court has refused to take the application on record. Let the learned judge file the report before this court. When the criminal matter.
22nd, 23rd is a holiday. 22nd.
On 21st of May 2024. The learned registrar is directed to communicate this order to the learned judge for compliance. Next.
I am for the petition.
Yes, who is appearing for the 14?
This is the first time it is being held.
Yes.
This is the first time this case is being heard.
Yes.
My lord, the petitioners are manager and deputy manager of the city center mall management, my lord, under the Ambuja Neotia group. So, my lord, the de facto complainant of this case alleges, if my lord can come once to.
So issue notice. Issue the notice.
My lord, this case is filed. I just want your lordship to come to page number 38 of once, my lord.
38?
Yes, my lord. One of my petition. Second paragraph, my lord, if I may be allowed to read it once. The purchaser hereof to this indenture is in need of a commercial place, has approached the vendor to transfer its rights in respect of the aforesaid property and has offered a sum of 82,89,000 for the aforesaid property. So this is written, and in the next paragraph it is written that this amount is the most offered and highest amongst the offered amounts. And my lord, in page number 40 of this very document, this is the registered deed of conveyance, my lord. See, in page number 40, my lord, there is a I'm sorry, my lord, 41, my lord. There, the second paragraph, the fifth schedule, it is written that 82,89,000 is already paid. My lord, the page number 40.
The last dictation.
Yes.
One second. There is a schedule, my lord, also. 45, my lord. Page number 45, my lord, there is a memo of consideration in which the payment, when it was made, there is a schedule and it is being signed by the transferor. The transferor is Shiv Shankar Shastri, father of the de facto complainant, and he transferred the property of his another daughter, that is Ankita Shastri. So now, my lord, the complaint.
No, where you got this from this deed?
From this deed itself.
Where is that? Conveyance deed.
Yes, ma'am.
Ankita Majumdar Shastri.
Right, ma'am.
She is the vendor.
she is the vendor. She has acted through her father, Shiv Shankar Shastri,
correct,
and sold the property to one Nikita Anand, my lord. The
Got-
consideration is written in this very deed. The memo of payment is also in this very deed.
correct,
It
correct,
is signed and endorsed before a registrar, my lord.
correct.
So now the complaint says that there is 25 lakh rupees which the seller should get. The complainant being the daughter, another daughter of Shiv Shankar Shastri, the constituted power.
Who has made a complaint?
The
Who is the complainant?
complainant is the daughter of the executor and sister of the owner.
Ankita.
Ankita's sister and Shiv Shankar Shastri's
Daughter.
man.
Yes.
I don't understand how she has a locus to file this complaint first in light of this
In
particular.
whose name the land was recorded?
This was recorded in the name of Ankita.
She is not no way connected with the property.
She has already sold the property. The
Anindra. The complainant.
complainant is Anindra.
She is connected with the property. The property is recorded in the
There is
name
no
of-
document as such. She complains of a theft of 40 lakh rupees clothes and furniture, but there is no CCTV footage. She admits it in her own complaint, my lord. If the written complaint be once read, it would be very clear, evident that a web of lies is trying to be getting established by way of this complaint, my lord. There is no cause of action, no documents. All the documents are against this particular complaint, my lord, and so is this petition. Sir, the petitioners are only, sir, managers and deputy managers of the mall, my lord. How can they be involved in? And most importantly, my lord, this is a unscrupulous demand from the de facto complainant, my lord. In the last page.
Okay, so what do you want now?
So I want quashing of this.
Quashing, let the state come. You saw the notice.
So till then, my lord, if they reside in Siliguri itself, I am making the service today itself, my lord. Next week it may be kicked.
Okay, so the
as
notice. So appearing for the petitioner. Police. Petition directed to serve the notice upon the state. Please the matter on 21st. Next.
Item number 2.
Yes.
Lord, there was the direction, the IO is present with the original CD. From the original CD, only a Xerox copy of the check was seized by the IO. So original check has not been seized. The Xerox seized along with the FIR, it was enclosed. This is the case.
Original was not seized.
Not seized.
Has
on the basis of
he issued notice under 91 for production of the original?
this I have seen.
Petition change किया है जेरॉक्स कॉपी से स्टोरेज का पता लिखा है लेकिन चेक नंबर शुरू लिखा है जेरॉक्स कॉपी लिखा है
Notice under
Because 91 is not issued.
91 was issued, but it relates to other documents.
No, with regard to the check,
No,
original
madam,
check.
no, madam.
So what document we required for that? This is a case of check. If he has not seized the original check,
But
how he
apart
can?
from the check, there are other amounts also, which were, so that is the section 420, 406 is there. madam.
What are the
It's
checks?
not the
What are
total
the-
amount. Madam, I'll just come.
Where is the FIR?
But I'll hand over the.
Item number 2. So 3 will come.
Why you were? Why you are restless? You sit there.
Madam, this
You sit there.
The complainant is the partner of ANP infrastructure, my lord.
Huh?
This complainant is the partner of an
No, that is correct.
my lord, and there was a complaint paid 90 lakhs. So out of that check was of 60 lakhs, my lord. So apart from that, huge amount is still there. Check is a part payment of that amount, which was dishonored, my lord. It's not that the entire case is based on the check and the charge.
That's why I wanted to see the where is the FIR.
FIR 46.
Huh?
46. So we have given the CD. This is the CD.
In the CD, where is the FIR?
After the
the fact.
Complaint is at page. I think.
This is the original CD, my lord. This is the A4.
না না অন্য অন্য আইটেম পিটিশনার লেখা আছে এই ম্যাটারে তো নয় পিটিশন
He will shoot for whatever. Index that.
What are the original document he has seized from to show that he has taken the loan other than the 60 lakhs? What are the original documents?
The original agreement is there.
The police will do with the agreement.
No.
Police will proceed with the agreement. Then close the all civil just senior division, junior division,
It's not
district
like
court.
that, ask.
I am asking one question from you. Show the document what the police seized with regard to the payment received by this petitioner. Original check, original receipts. Because you are not seized the original check. What are the other? Initially, you made a submission other than the 60 lakhs, other amounts is there. What are the documents you have seized?
I've seen it. The payment was made. The statement of the bank's opinion.
So. Which page?
This 117.
Huh?
117.
117.
Yes. Which one?
17, 10, 17.
This is 20. How much?
CD take a watch.
20 lakhs.
20 lakhs. Then
another one. 10 lakhs.
Correct.
17th next page.
Correct. This is of whose account?
One was from the account
This
of
is page number 17 is whose account? ANP.
ANP infrastructure.
Who is the ANP and infrastructure?
The complaint is the partner of ANP.
Okay. And then whether this amounts tally with the FIR. He has not mentioned anything about the HDFC and he has transferred and kindly see that. Kindly come to that. अपनी firm account किया था, that is 10 lakh, that is admitted in, that is a 10 lakh. So that amount he has given back. Other than the 60 lakhs, you are telling that the 90 lakhs. Where is the 90 lakhs? Other you show me, I will dismiss the application here in now.
Give me another 10 minutes, sir.
Show me the other 30 lakhs amount has been transferred other than the 60 lakhs.
My lord, definitely.
Next.
Item number 15.
My lord.
11 is passed over matter, my lord.
Pass over calling now.
Pass over matter, item number 15.
Lord, I'm for this stage.
My lord, I'm for the petition in item number 3. The supplementary affidavit has been filed showing the current status of the case. This is an application for quashing of the FIR arising out of a complaint under the Scheduled Castes and Tribes Atrocities Act, my lord. Our main ground for seeking a quashing is that this arises out of a civil suit, which was filed in 2009 against the de facto complainant. The de facto complainant, as a counterblast, at the very end, when he was a judgment debtor, and the bailiff and the police were at his door, he filed this case alleging that the petitioner had actually committed an offense under the schedule, asking him to go jungle. That is the substance of the case. Now, in our supplementary affidavit, the subsequent events are there after the present petition. 2 developments have settled between the parties at the execution stage, and the judgment debtor, the complainant, he purchased the entire suit property. That is at page 14 of our supplementary affidavit.
Yes, already the witness have been examined.
Yes, my lord. And
what purpose would be served of keeping this pending? Let you go and already you're facing the trial. Witness
we are facing my lord, may I just draw the court's attention to page 43 of the evidence, my lord.
Yes.
In the subsequent supplementary affidavit.
Yes. 43. Yes.
My lord is at 43.
Yes.
There are just 2 paragraphs I'll cite. The learned advocate for the Honorable High Court advised me, this is just at the bottom of the page. The learned advocate of the High Court advised me to file this case against the accused person as a counterblast to the civil suit which was filed by the accused Aftab Ahmed. I have no grievance against the accused person. My lord, my humble submission is that proceeding with this trial is an exercise in futility now and a waste of the court's time as well as a waste of the state's time and the witnesses, my lord.
Who is he? Who is the PW3? He is the complainant?
PW3 is the de facto complainant, my lord, the victim. And then over the page is his wife at page 44. And she says, on 21/9, I was present at Dambar Chowk. We were coming. We met with the petitioner, Aftab Ahmed, and there was a discussion between my husband and Aftab Ahmed. I have not heard as to what they were discussing with each other. Similarly, the niece of the victim also deposes at page 46 to the same effect. That will be a complete waste of the court's time. And at page 14 is the petitioner himself withdrawing the execution case because the
Petition, page number?
uh,
Page number?
I'll just take a minute, my lord. My lord, I'm just getting the page number.
Who is the PW1?
PW1 is the police witness, my lord, the recording officer. Because the complainant did not come, so the court proceeded with the recording officer's evidence. At page 41 is the civil suit, which was the civil execution case, which was withdrawn by the petitioner against the de facto complainant.
This is exhibited, no?
This is not part of the criminal proceedings. This is the civil suit where the court has disposed of the execution case. On being asked to the decree holder, he stated that the matter has been amicably settled between the parties and the judgment debtor was purchasing the sued property from him. Decree holder stated further that he has no objection if the necessary orders were passed. Hence, it is ordered that the case be disposed of.
Yes.
Actually, it was a pure and simple civil suit, which was converted into a criminal proceedings, my lord, and the ratio B. Venkateswaran's case of the Supreme Court squarely is on this point.
Yes, who is for the state?
Madam, for the state.
Yes.
But although the case diary, my lord, there are some materials during the course of investigation collected that the offense of the SC/ST Act was attracted. But now, my lord, in the evidence, my lord, if this has come, my lord, I have nothing more to say.
What is the stage? Last evidence?
Yes, evidence going.
When is it is fixed?
Next date?
When it is fixed, last date?
Lord, 4th of June.
For
evidence of IO.
4th of July. 4th of June.
4 June.
4th of June. For evidence. Now just the investigating officer and a this is at page 45, the order is there.
The petitioner has filed the present application being CRR 292 of 2022 under section 482 of Code of Criminal Procedure, 1978, praying for quashing of the FIR registered against the petitioner dated 24 September 2022 in Kalimpong Police Station case number 259 of 2022 dated 24 September 2022 under section 3 within bracket 1 numerical within bracket small x of the scheduled caste and scheduled tribes within bracket prevention of atrocities bracket close Act, 1989, corresponding to special GR case number 4 of 2022, pending before the Learned Special Court Medicine Session Judge at Kalimpong. Full stop. On the basis of the written complaint of the complainant, written complaint of one Palden, P-A-L-D-E-N, Palden Sherpa, S-H-E-R-P-A, Sherpa, dated 24th of September 2022. The police of PS Kalimpong had registered the above case. After registration of the FIR, the police has initiated investigation, and on completion of investigation, the police has filed charge sheet. And now the case is before the learned trial judge. And the stage of the trial is named and before the trial judge and is pending for evidence of the witnesses. In the charge sheet, the prosecution has, where is the charge sheet?
Judge. It's page 20 of the supplementary help. Starts at page 18.
Prosecution has cited 6 witnesses. Out of 6 witnesses, 5 witnesses have been examined, and the next date is fixed on 4th of June 2024 for evidence of the investigating officer. Full stop. The learned counsel for the petitioner has drawn the attention of this court to the evidence of the complainant who was examined before the trial court as PW3 on 6th of May 2024. In her evidence, and in her evidence,
My lord, it's a it's a male, Palden
yes,
Shepherd.
in his evidence, not her,
Yes.
in his evidence, comma, in her, during his cross-examination, he has stated that, inward comma, the learned advocate of the Honorable High Court advised me to file the case against the accused person as the counterblast to the civil suit which was filed by the accused Aftab Ahmed. Inward comma close. In the cross-examination, she has further stated that I have no grievance against the accused person. Full stop. PW4, who is he? Is the wife.
Wife.
PW4 is the wife of the de facto complainant within bracket PW3, and she has stated that in her examination in chief that while we were coming from home, we met with Aftab Ahmed and there was discussion in between my husband and accused Aftab Ahmed. Full stop. I have not heard as to what they were discussing with each other. Full stop. I have nothing more to say in this case. PW5. Who is he? PW5?
She is the niece.
PW5
She is the niece of the alleged
niece of the
victim.
de facto complainant. And during her evidence as PW5, during her evidence in examination in chief, she has stated that when we were coming towards Dambar, D-A-M-B-R, Dambar Chowk, at the time, the accused Aftab Ahmed, crossed us. There was an argument in between Aftab Ahmed and Palden Sefra, P-A-L-D-N, Palden Sefra, full stop. Both of them had altercation as tenant and landlord. Full stop. The other 2 witnesses are the police witnesses, and now the case is pending for examination of investigating officer. Full stop. It is also on record that there was a dispute between the de facto complainant and the petitioner, and the petitioner has got the decree in his favor. Subsequently, where is the compromise?
Compromise. Yeah. Supplementary affidavit. My lord, I'm so sorry.
Yes,
The
33.
execution case.
33.
43.
Memorandum of provisional agreement.
No, you stated that one agreement was just you.
One
you're saying-
agreement.
One moment, my lord. Civil suit. Page 41.
क्या बोला? Petitioner decree, and thereafter he filed an execution case. And in this said execution case, both the parties have compromised the matter, and the de facto complainant has handed over the possession to the petitioner.
My lord, he has agreed to purchase the suit property.
Instead, the matter has been amicable between the parties and prayed for passing necessary or the petition. No, here it is amicably settled and appraise the judgment after for agree. Acha.
Purchasing the
Yes.
both the parties have compromised the matter and the defective complainant
The complainant purchased the property from the
The,
petition.
agreed to purchase the suit property from the decree holder, comma, the accused and the petitioner here. Full stop. Consider the submission made by the counsel for the respective parties. Peruse the materials on record. Though on the complaint of the de facto complainant, case under the SC and ST Prevention of Atrocities Act has been initiated, and during the investigation, the police has found sufficient materials and filed the charge sheet. But during the trial, comma, neither the de facto complainant nor the witnesses have supported the case of the prosecution. Now, the case is at the stage of examination of the investigating officer. This court finds that no fruitful purpose would be served if this court will allow to continue with the criminal proceeding before the learned trial judge, as the investigating officer will not improve the case against the evidence given by the de facto complainant in the present proceeding. Accordingly, this court find that this is a fit case where the proceeding is required to be caused. Accordingly, the proceeding in connection with FIR number
259 of 22.
FIR number 259 of 2020 of PS Kalimpong
Of 22.
dated 24th September 2029 under section 3(1)(x) of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act, which is now pending before the special court, come additional session judge at Kalimpong, is set aside and quashed. The petitioner is discharged from his bail bond if he is not required in other cases.
My lord, my submission may kindly be recorded, my lord. My submission, my lord, that sufficient materials were collected during.
That I recorded. Collected prima facie, but the de facto complainant is not supported.
I'm grateful.
Very grateful.
May I,
Dispose of. CRR so dispose. Yes.
May I, my lord, the petitioners are charged, where the FIR was filed under 14A and 14C of the Foreigners Act, my lord. Complied with 188 and 447 of the IPC.
What is this? This is appeal?
No, CRR, my lord.
What?
Revision. My lord, revision. The
How the revision? He has pleaded guilty.
My lord,
He has
for the
been
reduction,
convicted.
yes, my lord, for the reduction of quantum of sentence.
Maybe you file an appeal and pray before the learned appellate court for the reduction. How in the revision it can be reduced?
My lord, in
how the revision is like?
No, my lord, in Foreigners Act there is no ground of appeal. There is no section for appeal.
Foreigners Act, there is no section of appeal. So CRPC will not applicable. If he has pleaded the guilty, he has been convicted.
Yes, my lord.
He
My
has
lord,
been
for, yes,
pleaded
for only for to the extent revision to the extent of reduction of
under which
sentence.
provision?
My lord, then a 1 day's time may be given. I will come with the provisions.
Sir, you have been faced the trial.
My lord.
When the plea was recorded, the charge was recorded, you have pleaded guilty.
My lord.
Correct.
My lord.
And sentence has been imposed.
My
That
lord.
is the conviction.
My
If
lord.
a person has been convicted,
My lord.
whether revision will lie or appeal will lie. Either you, because in the appeal only you can pray for the reduction of the sentence. And
But
if
will
the appeal, if it
the
is
question comes, my lord, will after pleading of guilty, for the extent of quantum of reduction of sentence, will the appeal lie? Because I have pleaded guilty.
you file an appeal, pray for quantum some reduction of sentence. How the where is the provision for reduction of the sentence? A revision is applicable. Where is that? Show me.
My lord. My lord, then kindly, I would withdraw the petition. Kindly, this certified copy may be returned. I would file the appeal tomorrow then.
Tomorrow not here. Who has convicted?
ADJ first court, Metliganj, ADJ, then it will be High Court, my lord.
ADJ?
Yes,
ADJ?
ADJ.
Not the magistrate?
No.
Where is the conviction?
My lord, it is in from page 14, the certified copy, order number 1.
Page number?
14, my lord. It is the certified copy section.
Achha. That is a session judge.
My lord.
What is the section?
14A.
Achha, 14A. Okay.
14A, my lord. So
what you want? Withdraw and file appeal?
My lord, my lord. My lord, then can it the certified copy may be returned?
So appearing for the petitioner. Police. The petitioner for withdrawal of the instant revision application with the liberty to file an appeal,
my lord,
against the impugn order. Police. Counsel for the petitioner press for return of the original certified copy of the order by replacing the Xerox copy of the same. Consider the submission made by the counsel for the petitioner. CRR number 175/2024 is dismissed as withdrawn. The petitioner, the original certified copy be written to the petitioner, subject to furnishing the copy of the same.
My lord, highly obliged.
Yes, next.
Also, item number 6.
Yes. Whose appeal? He left.
Section 5 grand.
There's
a delay of
I called whether and this is the format you are taking as an appeal in the criminal. So yeah, you ask, but the department is telling that this format, this is not the format. Yes, who is for the petitioner? Here, where he left. How many days? What is the section? SCST Act. By the special judge. Acha, against acquittal. Against acquittal. When the order was passed, May 2022. Now they have filed. So notice is to be issued. You are appearing for estate. The notice is to be issued before hearing, because section 5. I don't know.
Does mere filing a section 5 application doesn't mean it will be allowed.
Where is? Who has filed this? Kalyan Chakravarti. Okay, pass over. Pass over. Next. 11.
My lord, I am for the petitioner, my lord. Am I audible to you, my lord?
Yes.
My lord, the petitioner before your lordship is the husband of the OP number 2. Out of the misunderstanding, the OP number 2, who happens to be the wife of the petitioner, lost this instant case, my lord. Now they are happily living as a husband and wife. Compromise has been made out, my lord. My lord, kindly fix the matter on Monday. We will file the joint application.
What is the section?
My lord, the section are
354, 498A.
Yes, my lord. 313, 354B, read with section 31EG, 32 of scheduled caste and scheduled tribe.
Scheduled caste and scheduled tribe?
Yes, my lord.
So how it is compoundable?
My lord, the question is not about the only compoundable. My lord, the respondent and the petitioner are the husband and wife. They are living happily. Their marriage is now happy.
So how the SC/ST Act?
My lord, at that moment, the subscriber aggravated the allegation, my lord, that the petitioner also abused the respondent by calling her in Adivasi's name.
Okay. When? 21st?
Yes, my lord, 21st.
As per the prayer made by the counsel for the petition, let the matter appear on 21st.
Grateful, my lord.
Next.
Item number 3.
Yes. 2 or 3? 2. Yes. Yes, 2. Is there any amount is there?
There was a deed of agreement, development agreement, which was registered. And as per the registered contribution amount is of the amount. And the same as feature short of the last.
There is nothing. There is nothing. That's why I'm saying to save. So where is the transaction? Maybe agreement. Where is the transaction? Show me the transaction. Either receipt or the bank. You show me the receipt because you are investigating for the last 2 years, 3 years. 3 years, whether he has, where is the evidence recorded, 161, whether the complaint stated that he has initiated the 138 proceedings. Thereafter, then it's not the case. Agreement, how the criminal? So you have to prove. So that's why you have to prove the strict proof before the court in the criminal trial. What is the stage of the investigation? 2021 matter. Today we are on 24, 3 years. What is the stage? Charge sheet filed. Then 3 years you are taking. That's why the cases of document, that's why I'm asking only 2 documents, 60 lakhs, okay. Check with regard to the other, where is the document you show me? Where are the documents for the other amount? He has taken and not returned. Can the criminal get all these things taken into consideration?
There is the evidence of cheating. The bill which was offered into the conditional bill, that cancellation has already been taken.
Cancellation done, that's correct. That's why the court has passed an ad entry order. Entry order is there. I am ready. I am going to that only. What so? You kindly come to the page 320. 320. Opinion of the IO. The last 3 lines. Later, after the completion of the PC, remand period of return of PC, accused connected the papers. He collected the bank account statement of the Satyendra Kumar Pandey, who were clearly evident there is a several amount has been credited on the said bank account from ANP infrastructure. Several dates. Also collected the bank accounts. Where is that? Where is that? Cash, how you can? How you will prove? That's why how you will prove? So you go to the, let it prove in the civil court. Now, how the criminal court will deal with the cash amount dealing and all these things. Then and 138 already 16 lakhs 138 he has initiated. He has not taken the check also. He has not called for the check also. And he has not recorded the statement of the witness, the complainant also. Yes, he has used the original check in the CR case. IU has not recorded that also. Then abuse of process. Abuse of process. Finally, come to the paragraph, the complaint itself. Complaint, written complaint. Written complaint, second page. Written complaint on the basis of which the FIR is chalked out. Last line, last English, it is in English, I think so. Last line. मैं अपना पैसा वापस वापस चाहता हूँ. कानूनी मदद से मैं अपना पैसा वापस पाना चाहता हूँ. I want to recover my money through the legal assistance. So and so appearing for the petitioner, so and so appearing for the state. The petitioner has filed the present application under section 401, read with section 482 of the Code of Criminal Procedure for quashing of proceeding being GR case number 68 up to the 19, arising out of Martigara Police Station FIR number 12 of 2019 under section 406, 420, /34 of the IPC. 406, /34 of the Indian Penal Code, 1860. Full stop. The police of PS police of Martiga and the police of PS Martiga had registered an FIR on the basis of the written complaint of the opposite party number 2. Of the opposite party number.
Opposite party number 3, my lord.
Opposite party number 3. Full stop. The opposite party number 3. Full stop. As for the FIR, there was a business transaction between the petitioner and the opposite party number 3, out of which several transactions were made. Business transaction between the opposite party number 3. Full stop. The petitioner had issued a check number 002017 dated 30th October 2018 for rupees 60 lakhs of Union Bank of India in the name of the opposite party number 3, and it was also assured that the remaining amount of rupees 30 lakhs will be returned by December 2018. It is also alleged that on inquiry from the bank, the opposite party number 3 came to know that no sufficient fund is available. Accordingly, the opposite party number 1 has filed the case. Opposite party number 3 has made a written complaint to the concerned police station. In the complaint, it is also mentioned that he wants to recover his money through the legal assistance. Full stop. On the basis of the said full stop. After registration of the FIR, police has investigated the matter and the petitioner was arrested. Full stop. In the meantime, the petitioner and the opposite party number 1 have settled the dispute. A compromise agreement was entered, and on the basis of the compromise agreement, the petitioner was released on interim. Full stop. But subsequently, the petitioner failed to appear before the Learned Trial Court, and accordingly, warrant has been issued. Full stop. The petitioner has filed the present application for quashing of the proceeding on the ground that the dispute between the petitioner and the opposite party number 3 is in civil in nature, and the check on the basis of which the opposite party number 3 has initiated the case, being check number 002017 dated 30th August 2018 for rupees 60 lakh, against the said check, the opposite party number 3 had already initiated a complaint case before the, where is that details? Before the court of
London Magistrate, NI Act, Allahabad.
Before the London Magistrate, at Allahabad. Full stop. At Allahabad. The Magistrate of Allahabad had taken cognizance and issued notice to the petitioner for appearance of the petitioner before the Learned Court at Allahabad for the offence under section 138 of the NI Act. Full stop. This court has called for the case diary and also directed the investigating officer to appear before this court in person and the investigating officer is present along with the case diary. When this court has inquired from the investigating officer whether the police during the investigation has seized the original check, big number 002017 dated October 30, 2018 for rupees 60 lakhs, the investigating officer stated before this court that the investigating officer has not seized the said check. Only the complainant, only the OP number 3 has handed over the Xerox copy of the said check. Though the case was initiated in the 2019, till date the investigation has not been completed. Even the investigating officer has not recorded the evidence, recorded the statement of the opposite party number 3 to the effect the opposite party number 1 has used the impugned check in the other proceeding before the Allahabad court, and the Allahabad court has also taken cognizance of the said check and issued notice to the petitioner, and the said case for the offence under section 138 of the Negotiable Instrument Act is pending. Full stop. The investigating officer, full stop. The state failed to show any document from the record to continue with the investigation whether the other transactions have been made by the opposite party number 1, opposite party number 3 with the petitioner, as the investigating officer has not seized any document, either bank statement or any money receipts or any of the statement of the independent witness to show that other than the 60 lakhs rupees, there is any other transaction made between the petitioner and the opposite party number 3. Full stop. In the case diary, the investigating officer has recorded that sufficient material has been found, but when this court has directed to produce the materials to establish the further incriminating materials against the petitioner, so that the trial of the case can be proceeded, but the prosecution failed to show any document other than the check, that is also the Xerox copy which was seized, and with regard to the same transaction, the bank account was seized. Bank statement of the bank was seized from the concerned bank. Considering the above facts and circumstances, this court finds that the opposite party number 1 has
opposite party number 3,
opposite party number 3 by cleverly only to settle the monetary transaction between the parties had initiated the present criminal case, and on the other hand, the opposite party number 3 had initiated another proceeding for the same amount of the said check for the offence under section 138 of the Negotiable Instrument Act, and the Learned Court of Allahabad, Learned Magistrate at Allahabad had taken cognizance of the said matter, and the case is pending before the Learned Magistrate before the Allahabad, before Learned Magistrate at Allahabad. In view of the above, this court finds that this is a fit case wherein the proceeding initiated by the Martiga police station, being FIR number
12. FIR number 12 dated
12
719
of 2019, dated 7th January 2019, under section 409, 420, 34 of the IPC is required to be
406,
right, and accordingly it has been set aside. Consequently, all the proceedings pending before the London magistrate at which court? London magistrate at which court?
Additional judicial magistrate at Siliguri.
Additional judicial magistrate. Additional chief judicial magistrate.
Chief judicial magistrate.
Magistrate at Siliguri.
Siliguri.
At Siliguri, being GR case number 68 of 2019 is also set aside and closed.
Deeply obliged. Deeply obliged.
The warrant issued against the petitioner by the London magistrate is recalled. Next.
Grateful, my lord.
So disposed of. 15.
But item number 50, I am not pressing this application.
Not pressing?
We don't this application.
Why?
And the client does not proceed with the case.
What is the matter?
My lord, 125 matter, my lord.
Sense appearing for the petitioner. And counsel for the petitioner submitted, he has instruction to not press the present application. Accordingly, CRR number 168 of 2024 is dismissed as not present. Interim order, if any, stand vacated. If any, stand vacated. Next. Dispose of. Next. 16, who is appearing? Nobody. None appears. On behalf of the petition, no accommodation is sought for. Leave the matter on 21st. Next.
Item number 17.
None appears. Leave the matter on 21st. Next.
For item number 17, I have been instructed for
Yes.
a passover, my lords. 16, 17, my lords, advocate.
21st.
Wait.
Next.
17, item number 17 or 18?
18.
The petitioner in the instant matter. My lord, my lord, I am appearing on behalf of the petitioner in the instant matter. My lord, 18.
Yes.
Item number 18.
Yes.
My lord, I am appearing on behalf of the petitioner.
I am appearing for
Because
the
this
schedule, lord.
case, I have come up for quashing. I have come up for quashing of the instant case. Case was started under section 354. Chanda. Case was started under section 354. My lord, your lordship, kindly come to the, here the charge sheet has already been submitted. But kindly come to written complaint, that is P1. P1 of the written complaint. One of my colleague lost the page 19. Page 19, respected sir, madam. Your lordship got it, my lord?
Yes, yes.
My lord? Got
Yes,
it?
got it.
I, such and such, Paramita Datta.
Yes, yes, continue.
My lord, I, such and such, Paramita Datta, residing at such and such place, wanted to register a complaint about sexual harassment at workplace against the company, because I am a freelancer of this company, and I have 1.5 years of working experience with this company. This company does advertise indoor events as well as corporate programs. Next page, you'll also kindly come. The incident of the harassment with me happened in Kalimpong, West Bengal, 15 September 2023. I traveled to Kalimpong from Kolkata by car with my fellow employees.
With my fellow co-workers.
Co-worker, yes. Kindly pardon me.
Not fellow.
Obin Mondal, Chiranjeev, Ramtij and Ramani and Devashish Sarkar ran a corporate program held in the hotel Sinclair's Kalimpong in collaboration with of 16 September Courtiers on 16 September 2023, 15 September. We reached Kalimpong 14 September 2023. We got accommodation in a place and 7 mile, such and such, phone number such and such. The proprietor of this company, Sandeep Sinha, was not present there currently, and his partner, Somen C, who was leading the property, did not produce a receipt, provide separate room for a female worker. I had to share the room with 3 male workers, Pradip, Chiranjeev and Devashish. Then my next page. Due to separate room, I preferred to sleep on the floor mattress in a room with other 3 workers. They were sleeping on the bed. My co-worker, Devashish Sarkar, who is also relative, cousin, the proprietors of this company, Sandeep Sinha, used to tried to molest me. 16 night, I was sleeping on the floor mattress, and suddenly I woke up, felt that Devashish Sarkar was touching my body and a chest and way, and he was laying on the floor on my.
Okay, let me return on notice.
On my.
What you want?
Due to your lordship, I want the entire proceedings be quashed. I want entire proceedings should be quashed because 354, my lord, if your lordship kindly come to 354, pardon me, my lord, I am reading Section 3, assault on criminal force to woman with intent to outrage and modesty. Whoever assault or uses criminal force to any woman intending to outrage or knowing it to be likely that he will thereby outrage her modesty with in description which shall not be less than 1 year. That is the punishment. But here, if your lordship kindly see the entire complaint as well as charge sheet, as well as, my lord, ingredients of the offense is very much absent in the instant case. And my lord, and one thing, if your lordship, I am not there, Jalpaiguri, for which the unfortunate, I'm appearing before your lordship, my maiden appearance. And if your lordship, the unfortunate, I have not gone to Jalpaiguri. Few scenes are there. He lost the complaint. Incident took place on 16/9/15 and lost the complaint on 23rd after 7 days, 23rd. And in the meantime, 7 days, agent woman, if your lordships kindly see how in his Instagram and also, I don't know, you also kindly see how he has spent all those days of 7 days, which appears from the Instagram. And these are our photos. But I have been implicated the weapon to harass me. Nowadays, some of the ladies, they are harassing an employee, and it is not in a workplace. It is, he has stated that it was workplace. It has not happened in the workplace, assuming but not admitting. And there is no eyewitness in 161 statement. If you all have annexed it, that all are hearsay evidence. So, my lord, I'll serve copy, and your lordship kindly fix a date for hearing. I'll serve, and also your lordship. But this is a picture around 7 days. Nowadays, my lord, some of the ladies weapon harassment. You will also kindly come to the
yes. Issue the notice. Issue notice. So appearing for the petitioner. You are appearing.
Yes, I am appearing for
Receive the
the
notice. State. So appearing for.
In the meantime, my lord.
So appearing for the state. The petition is directed to serve notice upon the opposite party. Number 2. Place the matter before the next circuit bench.
My lord, in the meantime, my lord, stay of the proceedings, my lord. My lord, pardon me, my lord. My lord, kindly give me a reply. I am praying for stay, my lord. Do not take me, I am grateful, your lordship. Grateful.
Yes, next.
My lord, I'm on behalf of my lord, I have filed this case under section 407 of CRPC, my lord, for transfer of a criminal proceeding from Alipurduar to Jalpaiguri. Actually, my lord, the alleged incident was happened. My lord, the respondent number 2 is the wife. She made the complaint before Kumargram police station, which is under Alipurduar district. She was married to petitioner number 3, and their marriage was solemnized on.
That husband and wife.
Madam?
Husband and wife.
Husband and wife and all in-laws are there.
498.
Yes, my lord. My lord,
when the case, where the case was registered?
Case was registered at Kumargram police station under Alipurduar district.
Correct.
And the alleged incidents was happened at under Bhaktinagar police station, which comes under Jalpaiguri district, my lord. And the last occurrence was alleged in page number, my lord, though it is in Bengal.
Have you issued the notice?
My lord,
who is appearing?
Application only for
serve the notice. The transfer matter, transfer. State is to be heard.
State has made him.
Has served.
No, copy has not been served.
Motion stage,
huh?
Or admission of.
Sir, the copy. What is the admission? This is the application.
Well, I'm praying for stay in the proceeding, my lord. For
what is the stage of the proceeding now?
My lord, the petitioner has got bail from the court below.
Charge sheet filed.
Charge sheet not filed.
Then you want the transfer.
Yes.
You are on bail. Charge sheet not filed. Trial. There is no urgency in the trial. Trial cannot proceed. You are only the trial with regard.
By chance, they will. Police will.
How the charge sheet is to be filed, then the charge is to be framed, then the witnesses. So what is the necessity of the? You serve the copy. You serve the. So offering for the petitioner. The petitioner has filed the present application.
My lord, I'll serve today or tomorrow. I will come back in next week, my lord.
Okay. File the petition. The petitioner has filed the present application under section 407 of the Code of Criminal Procedure for transfer of the case from the Learned Court of Chief Judicial Magistrate Alipurduar to
Jalpaiguri. Chief Judicial Magistrate Jalpaiguri.
To any of the magistrate court at Jalpaiguri. Police. This court find that before passing any order, and this could find that the estate is to be heard in the matter according to the petition.
The private party also, because that.
Yes. Transfer on the part. Transfer case. So you.
Witnesses will be.
Witnesses' interest is to be taken by the prosecutor, not the witness come and before the High Court and say, no, I will not. It is a prosecution. Heard accordingly, the petition director.
One thing can be done. If it is so, then he can serve the copy on us, and if might not think, then.
I am fixing that centrally. Serve the copy to the Learned Counsel for the State. This is the matter on 21st, na? Criminal?
21st.
21st.
Second number 20.
Lordship, I'm appearing on behalf of the petitioner. There are two petitioners in this case. Number one, petition number one is the husband of the de facto complainant, and second is the brother-in-law, elder brother-in-law. Now, what's a very sorrow state of affairs. This is the second FIR against them. Initially, FIR was lodged under section 498A. It was in Birpara police station. Subsequently, this FIR is of Bhaktinagar police station.
Who has registered is 354?
354. 354 should be against the brother-in-law.
No, the earlier who is the complainant?
Oh, same complaint, de facto complaint, wife. Wife of the petitioner number one.
Okay.
Now the fact of the case, Lordship, please, I will narrate in page number 17. It's is the FIR.
17?
17. It's a very short FIR, a cryptic one. 2 pages FIR, handwritten. With due respect, this is to inform you that on 14/1/2023 at 5:30 p.m., I was going to Shebok Road, Siliguri. A car came and stopped before me. I saw 2 persons with a knife and a wooden stick coming towards me. I tried to ran away or flee away from the spot, but they ran and catch hold of me. Saurav, it is the husband. Saurav thrashed me and beat me mercilessly, and Ashish showed the knife, and both tried to put me inside their car. They are all along abusing me and my parents with abusive words, stating, "We will not spare you if we do not withdraw the case pending against them." He's talking about 498. We are threatening to support the bail prayers of the rest of the accused persons and not to appear before the same, and will be murdered. And I resisted and shouted. Local people came to the place and they fled away, and I'm passing. Now, Lordship, this FIR was lodged in 18/1/2023. We obtained bail, the bail about which she is talking about. We obtained bail that we will get in page number 29 and 30. We obtained bail on 27/12 and 5/1/2023. Two CRMs were filed. Subsequently, on 5/1, the year got exhausted. Now the complaint is of 18/1. An incident which she is narrating is of 14/1. So our last bail application was allowed on 5th of January. So there is no question asking her first. Second, Lordship, this is the handwritten FIR, and you will get another FIR in page number 57.
57.
57. Now we will see what she was into. It is a typed FIR, same complaint, same thing, just the date is different. Same complaint, everything is same. 57.
Yes.
Everything is same, other than this is a type complaint, same incident, but this was filed before the police on 15/1. Now, how I get hold of this, Lordship? I got hold of this when a cancellation was filed against my 498. I got hold of this. So there was complaint made on 15/1 and 18/1.
Yes.
Lordship, now, Lordship, you will get from the FIR, that is the written. I'm considering the written FIR as the main FIR. That is in page number 17, which I've already gone through. He categorically stated that local people came and saved me. Now, at the time of closure of the investigation, during charge sheet, a relative came into the picture and 161 is recorded. That is in page number 24. An eyewitness certainly clocked up. 24. Whereas in the FIR, she is stating that local people came and there was no whisper about any relative or whatsoever.
Yes.
In page number 24, Pramod Sharma. Shall I read out the Bengali?
Yes, yes.
আপনার জিজ্ঞাসায় আমি জানাচ্ছি যে আমি সুস্মিতার জামাইবাবু গত 14/1/2023 তারিখে বিকেলে আমি এখানে পাশেই একটি দোকানে ছিলাম রাস্তার উপর সুস্মিতাকে চিৎকার করতে দেখে আমি ওখানে ছুটে আসি এবং আমাকে এখানে আসতে দেখে সৌরভ ভরদ্বাজ এবং আশিস শর্মা এখান থেকে পালিয়ে যায় আমি সুস্মিতার কাছ থেকে জানতে পারি যে সৌরভ ভরদ্বাজ এবং আশিস শর্মা তাকে রাস্তায় আটকে গালিগালাজ করছে এবং মারধর করছে তারা সুস্মিতাকে তাদের গাড়িতে জোর করে তোলার চেষ্টা করছিল কিন্তু সুস্মিতা চিৎকার করতে শুরু করলে তারা সেটা করতে পারেনি দয়া করে উপরোক্ত দোষীদের বিরুদ্ধে উচিত আইনি ব্যবস্থা নিন এটাই আমার নিবেদন নাও লর্ডশিপ the 498 case is little bit relevant here before that I will show you the injury report collected by the year injury report is in page number 25 lordship very interesting incident is of 14/1/2023 and see the date of injury and when it was collected. Date of injury is 18/1/2023 and I was collecting it on 3/3/2023 from a private doctor. All this was made, lordship, with my humble submission, all this was made for the cancellation of the bail application. What happened to the cancellation, lordship? I will hand over a copy of the, lastly it was not placed after several adjournments. A view was taken by the division bench that there was no illegality in the order.
Yes.
Subsequently, what happened, lordship? At the last year, you will get on last page 16/11/2023. It was not pressed. This was just not pressed. Only 2 settled scores.
Page.
Last page, lordship. Last page of which are 16/11/2023. Lordship, not pressed.
Yes.
Now, lordship, if I go into the 498 FIR, lordship, you will see what I have been through. The petitioner number was as a husband. Lordship, please consider my 498 case. Lordship, it is in page number 26. And relevant page number 28. Only one para.
Yes.
One on 2/12/2022, page number 28.
Yes.
Lordship. On second paragraph. On 2/12/2022, after several months of absolute stress and terror, my husband.
Page number 20?
28. Second paragraph, lordship.
Yes.
On 2/11/2022, after several months of absolute stress and terror, my husband picked up a quarrel with me and started abusing me and my family and hit me with fish several times. And when I protested, he tried to strangulate me with his hand. And thereafter, on the instigation of the said in-laws, he threw me out of the year. So she is narrating an incident of 2/11/2022. Here, lordship, please come to page number 34, lordship. I was accompanying her.
This is the FIR of
490.
15/12.
And she is narrating an incident of 2/11/2022. Now, please come to page annexure P9, that is page number 34.
34.
34, lordship. On 2/11/2022, I was with her, taken her to a diagnostic center. This is the original reports I am holding. I have collected. Very unfortunate state of affairs, lordship. How this 498A and this menace.
Yes.
And lordship, 38 and 39 is the bill which I have paid. That is also original with. I'm having the original one with. What else a husband can do? sample collection date is 2/11/2022. On the top right hand side. And she is alleging that I have strangulated her and have driven out her matrimonial house.
Yes.
That is in, I have filed another quashing application that is appearing in the list today, and it is item number 43.
Yes.
Lordship, I have demonstrated my case. I leave it to your Lordship.
Who is for the state?
Lordship, this is the first time I am appearing, Lordship. If your Lordship permits, I do not need a stay also of the proceedings right now. I just want to get it disposed of before this bench.
Serve the notice.
Lordship. Can't fix any.
So and so appearing for the petitioner. The petitioner has filed the present application, praying for crossing of the proceeding being GR case number 274 of 2023 in connection with Bhakti Nagar Police Station case number 45 2023 dated 18 January 2023 under section 341, 325, 354, 504, 509, 506 plus 34 of the Indian Penal Code. Pending before the learned judicial magistrate first court at Jalpaiguri. This court find that notice to the state is required to be issued. Accordingly, petition is directed to serve notice upon the state. This is the matter on 21st. This order and this. Next.
My lord, I beg to appear for the petitioner in the virtual mode, my lord.
Item number?
Item number 21, my lord.
Yes.
My lord, I am the petitioner.
Lord, I have received
the yes, my lord. This is an application for quashing of an proceedings that was initiated under Negotiable Instruments Act, my lord. My lord, there is a very short brief facts. The entire case is an abuse of process of law. I say that because, my lord, the check was given. Although I had sufficient balance, it was returned. On the same day, I have paid the same amount to the opposite party respondents through RTGS, my lord. That is evident from my document. My lord, kindly comes to page number 19 once. I would show the check that I had first given.
Yes.
Page number 19, my lord, can see a check amounting to rupees 3,06,000.
Yes.
My lord, just after that, my lord, I have annexed my bank statements, my lord. At onwards 222, page number 22 onwards, my lord.
Yes.
My lord, at page number 22, first there is a transaction, my lord, which is seen that 3,06,000 sufficient, insufficient fund is there, is mentioned. But my lord, kindly see the balance. It is more than 3,41,000, my lord. But my lord, little bit low, there is another transaction of rupees 3,06,000, which I have sent to the opposite parties through RTGS on the very same day. When the opposite party informed me that the check was bounced, I immediately sent the said amount through RTGS, my lord. And even after that, they have come up with this false and frivolous case against me, my lord, which I am seeking quashing at this stage, my lord.
Yes. No, this page number 22.
Yes, my lord.
Like 6,000 deposit.
Yes, my lord.
Deposit. So return.
Yes, my lord.
Funds is insufficient.
Yes, my lord. Just below that again, my lord can see.
341. 3,41,000. But
my lord, my balance is 3,41,000 at that point.
No. What is the this account? What type of the account is?
This is the, my lord.
What type of the account?
This is the account of the petitioner, my lord.
Has to be a CC account, my lord, because it is a company that is involved here. My humble request is I have received the copy only today. My lord, may kindly keep it on Monday or whichsoever date, my lord, taking the CRR. In all probability, what instruction I have from the client is that this amount is apart from the and other than the RTGS transfer that he has done is apart from and other than the check amount. Because the total due
That
was
is
for 12
completely
lakhs,
misleading
5,000
statement, my
amount.
lord. My lord can see I have transferred the same amount on the same day. And even on the date when the transaction was made, I had sufficient balance in my account, my lord. That would be evident.
Where your transfer? RTGS, yes.
My lord, kindly see the transaction that is two items below the returned
Got it.
19/10/2022, my lord.
The total dues, my lords, was more than 12 lakhs 75.
RTGS,
And my lords,
my lord, RTGS amount of rupees 3,06,000.
Where is your notice? Under 138?
My lord, I have not received any notice, my lord. I never received the notice under section 148, my lord.
They have not annexed it, my lords.
Where is the notice?
They haven't annexed it, my lords. But what would be clear, my lords, from they have bought a land from me. And my lords, the total due, my lords, was at page 15, my lords will see.
Page 15?
Page 15, paragraph 2. This 3,06,000 is part payment against the outstanding amount of 12,75,000.
Yes.
So there is some confusion as to whether this is part of
Okay, come, Wendell.
Oh, come on.
So and so appearing for the petitioner, so and so.
My lord, this is a misleading statement, my lord. Kindly see the transaction on the same day I have given the check was withdrawn.
Yeah, this is their document.
So and so appearing for the petitioner, so and so appearing for the opposite party. Counsel for the opposite party, prays for fix the matter on next week. Let the matter appear on 21st.
I'm opposed.
Next.
Well, I appear for the petition.
My lord, I shall leave my name in the chat box.
Record the name of the.
My lords, I am a 62 years old Swiss national, my lords.
Yes.
The FIR is at page number 15, my lords. I am challenging the proceedings here. My lords, the allegation is that there was no arrival stamp in my visa. There was a valid visa and there was I had a valid passport as well. I'll show you from the FIR, my lords.
So what you want? Quashing?
Yes, my lords. This is an abuse of process, my lords, because I am a 62-year-old man, my lords. My mother is also ailing, my lords. I was granted bail by the lower court. There is a clear recording, my lords. I'll show from the order sheet as well that I was having a valid visa and everything. So merely,
what is the allegation?
Allegation is that I was not having that arrival stamp. And one more allegation is that I was not having...
Why you not put the arrival stamp?
Milords, what happened? I tried to enter through a land immigration from Singrauli border, Senoli land immigration. There, Milords, first they stamped my passport. But subsequently, they cancelled that. And as per the FIR, they say that I have admitted that they instructed me to go and take a flight from Nepal to enter here. Milords, due to language barrier and due to false assurances given to me by some local agent, travel agent, I entered after that, Milords, through a land border. Subsequently, on 12th, I went to the Darjeeling office for seeking permit to visit Sikkim. There, Milords, I was arrested. There they found that your passport is not having valid stamp. And from there, they found out that they alleged that I entered illegally.
Correct.
Only allegation is that I don't have a proper arrival stamp. One more allegation is that I don't have registration. But registration, I'll show from the law, it's not required. Only if I'm staying more than 180 days, then registration is required. So only thing is that I did not have a valid stamp. And my passport was valid from 19th March, visa was valid from 19th March 2024 to 18th April 2024. I was arrested on 12th April. On 15th April, they filed the charge sheet as well. Charge sheet has been filed in 3 days. On 15th, I get a bail as well. After that, my passport and everything was also returned by the lower court because I had to apply for extension. So that was also done, So, my only submission is that because power under Article 482, is inherent power, Lordships knows better than me. For the ends of justice, and to abuse process of law, and I have been instructed, I am willing to even, if required.
It is only section 14.
Yes, my lord.
What are the punishment?
Maximum 5 years. Punishment is maximum 5 years.
Not less than it is there.
Yes, my lord.
1 year or 1 5 years. No, not less than. Not less than.
Minimum nothing.
5 years. 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 5 So you go and.
It's abuse of process, Milords.
No,
Kind
not
of,
abuse.
Milords.
You're not having this
Milords,
stamp.
my bona fides, Milords. There is no
Bona
other
fide?
allegation. There is no other allegation.
If you're not having the stamp, which hotel you is put in? Whether the 15C
Milords,
notice,
all those Milords, all
whether
those,
the hotel owner has been
Milords,
arrested.
No.
With
Milords, in these cases, Milords, they travel in groups, Milords.
maybe
Milords, everything I have.
that is correct, sir. It is okay. You have not put your seal in the visa, in the passport.
Yes.
And you entered into the territorial jurisdiction.
Yes.
Which you're not having the seal. Correct. Then you went to the hotel. How the hotel person has
Milords, I had a visa, Milords, valid visa. Milords, kindly see I'll show you from the order, Milords.
Just a minute, just a minute.
In 3 days, I was granted bail, Milords.
That's
Otherwise,
correct.
how would I have been granted, Milords? Like, my Lord knows better than me. In Foreigners Act, it's very difficult to get bail also. Milords, there is absolutely no malafide intention, Milords.
Which national?
I am a Swiss national, Milords. 62-year-old, Milords. I am a senior citizen, Milords. What purpose will it serve? I have been instructed, Milords, he's even willing to sponsor any children or any kind of education needs. That also we are willing to do.
That's why I'm telling. That's why telling you take this, you file a petition, plead guilty, and prosecution take
Milords,
leniency.
I am under
prosecution take leniency, fine may impose and let it go.
Milords, Milords, I am invoking power under section 482. Milords has the power, Milords.
No, this court has power.
Yes, Milords.
But then it will be a precedent in future also.
Milords, but kindly peculiar circumstance, Milords. Kindly appreciate, Milords. I'll place other case laws as well. I'll place case laws as well, Milords.
Milord, this is one side of the story. But allow me to make my submissions.
And Milords, apart from this, Milords, I am also facing several difficulties.
And also fine. Yes.
I am also one more.
Yes.
I am also facing difficulties to find accommodation, Milords, in Delhi. And Milords, there are a lot of issues, Milords.
How you went to Delhi?
Milords, I am staying in Delhi because Delhi is my embassy, Milords. There is no bail.
Foreigners Act, you have been granted bail.
Yes,
After granted bail, how you proceed to Delhi?
Milords, because I was not getting any stay here.
Why? There is no civil rules. There is civil authority where the foreigners has to be taken into the.
But there is no detention center here, Milords.
There's no detention
center?
center?
No, there is no detention center here. So they are put up in the normal jail only, Milords, with the other foreigners.
That is different thing.
Yes.
Jail, there is no problem.
Yes.
But once the foreigners has been released, it is the civil authority, I think SP will be the chairman and he will take the custody of the person and he will be bound by some area. He cannot go beyond that.
Milords, my bail condition is that. Milords, kindly see page number 22 is the bail order, Milords. Kindly see page number 22.
Now, court cannot restrict. But the civil authority has to pass a order. Once the foreigners have been released from the custody by the order on the as per the order of the bail, then the civil authority has to pass a restriction order of the foreign national to roaming around the areas.
That has not been done. That has not been done.
So then again your case will be registered in Delhi. How you went to the Delhi?
Milords, I had no option. Milords, I have stated everything in my petition. There is nothing to hide, Milords. And Milords, I am 62-year-old man, Milords. Kindly appreciate, Milords.
Now, Milord.
Milords, what purpose will it serve to continue with this?
Now, Milord, the question here is, Milord, having a valid visa does not entitle a foreign national, Milord, to enter the territory if the immigration officials are of the opinion that his entry is not conducive in the interest of the nation. First thing. Second, Milord, when he was in the check post, the immigration officials, Milord, had refused his entry in the territory of India. Thereafter, Milord, he had taken a different route and he had illegally entered India, Milord, without going through the, Milord, the procedure of the immigration. So, Milord, yes.
That is the seal. Who will put the seal? The immigration only.
Yes.
That's why the foreign nationals who are coming, he has to report the immigration and immigration will see the visa is valid, then they will put the seal and you can go. And in that immigration, they will provide this the conditions, which place you can go and which place you cannot go.
Lordship.
If there is a restricted area, you cannot go to that area.
Yes. Now, my lord, so far as the visa is concerned, he was having a printout of an electronic visa.
Correct.
And whether that visa is, my lord, genuine or not, my lord, a report has been called for from the my lord,
your authority has passed the file the charge sheet.
Milord,
Now
page
how you can
25.
take
my lord, supplementary charge sheet could be
But
filed.
no,
there
Milord,
is,
page
there is no
25.
prayer.
Yes.
Can you see? Hence, due to consultation of the superior authorities, foreign national, there is no prayer for supplement.
Lord, the
Yes,
report,
and that has been recorded by
Lord,
the
the
lower.
report
No,
has
no, supplementary charge sheet is yes.
No, no, no.
Against the above noted FIR against accused person, supplementary charge sheet will be submitted after receipt of the passport verification report, sir.
Man, let's take page 25, Milord.
Kindly come to the charge sheet, last page.
Yes.
Last paragraph. Where passport verification has not been done.
Yes.
And how you
Milord, kindly see page number 25 of the lower court's order, Milord, what they have recorded.
See.
No, the trial court has recorded this. Milord.
What?
That the charge sheet has already been submitted in this case after completion of investigation.
Huh.
There is no prayer of the prosecution for further investigation or submission
Correct.
of supplementary charge sheet. The IO has merely submitted an application to the appropriate authority for verification of the genuineness of the documents.
Correct. That's why they kindly come to charge sheet, last page,
Yes.
last paragraph.
Yes.
Verification is required, report is required. So at this stage, how it can be?
Yes.
Milord, kindly ask them to produce a report before this court. Milord,
How?
could be?
The court cannot direct. They will file when the report will come. They will file a supplementary.
Then kindly give me
Next circuit. Go to the next circuit.
Okay.
As per the prayer made by the citizens appearing for the petitioner, citizens appearing for the respondent, I state, as per the prayer made by the counsel for the petitioner, let the matter appear before the next available circuit.
Lord, let the case diary be also called for in the intervening.
Yes, that will.
Let the judge. I am not hearing.
I'm great.
My lord, my lord, I am for the petition, item number 22.
Yeah.
Appearing hard sheet.
My lord, there was a direction to serve upon the respondent. We have sought the affidavit of service may be taken on the record. My lord, may be pleased to hear this matter finally on Monday.
Yes.
My lord,
Who is for the authority? You are for the state. Yes. What is the prayer?
My lord, senior counsel in this matter lives in the courtroom number 9, principal bench. Kindly heard this matter finally.
Counsel for the petition, the case is adjourned. Let the matter appear before the next available circuit bench. Next. Next. Call. Yes. Against acquittal. Yes. How many days?
258 days delay.
258 days.
But I filed the section 5 application.
Section 5 application. CRAN number?
CRAN 10-1.
Yes. Where is the cause you shown?
Page paragraph number.
Financial problem.
Financial problem.
They were not guided properly, hence there is a delay of filing in this.
Yes. Next.
Paragraph 4, Marital.
Yes, I've gone through. That's all.
That's all.
What is the matter? Where is the evidence which the judge has not considered?
But actually, in this matter, I am not the advocate record, Marital.
Sir, this is a special leave. You have to satisfy with regard to the which evidence the learned judge has not considered, that is to be considered for conviction. That is the only point for admitting the appeal against the acquittal.
Kindly make it, Marital, next week, Marital.
All matter next week.
No, Marital. Mr. Parthoputim Rai will appear, Marital. He will assist you better.
As per the prayer made by the counsel for the petitioner, case is adjourned, let the matter appear before the next circuit. Before the next available circuit bench.
Item number 24.
24.
Yes, Your Lordship.
Yes.
My lord, this revisional application has been filed, my lord, challenging the order, judgment and order dated 3rd of February 2024.
Where is the
passed
order?
By the learned additional session judge, my lord, in criminal appeal, my lord, thereby modifying the judgment of the judicial magistrate filed by the opposite party one herein as a de facto complainant under 138 of the Negotiable Instrument Act. Now, my lord, the allegation says that pro forma opposite party 2 herein, my lord, he is a private limited company and for exporting of potato onion to Bangladesh. And the petitioner was the director of the pro forma opposite party number 2, who was, my lord, who was director up to 3rd of January 2016. Thereafter, he resigned. My lord, the complainant, my lord, who is the opposite party number 1 herein, he made a complaint under 138 of Negotiable Instrument Act that he is running a wholesale business of onion from whom the petitioner and the pro forma opposite party number 2 used to purchase onion for export to export to Bangladesh. Now, my lord, 2 checks were issued by the director, who is the petitioner, or the pro forma opposite party number 2, who is the company, in favor of the opposite party number 1. Those 2 checks were presented number of times before the concerned bank. My lord, 2 or 3 times it has come with an endorsement of insufficient fund, and 3rd, it has come as stop payment. So thereafter, they sent notice in compliance of 138B of the Negotiable Instrument Act that was refused. Taking into consideration of that refusal as a good service, this complaint has been filed. Now, my lord, this is the allegations. Now, my lord, what happened? My lord, the checks, those 2 checks were given to the opposite party number 1 as security deposit. Because, my lord, those 2 checks were blank, only the signature was there. That is corroborated with the depositions of the PW1, who is the power of attorney holder of that company, and PW2, who is the accountant. Secondly, lordship, it was also evident from their depositions, because they could not produce not a single document to that effect that they have my lord, they have handed over the material, those onion and potato to the petitioner number 1 or the opposite party number 2. So, my lord, they could not produce any documents. Thirdly, to that effect, that they have handed over the things. Thirdly, lordship, according to, they have, my lord, presented the check. According to them, according to their complaint, that with the petitioner director, my lord, as per his instruction, they presented the check. But, my lord, not a single document they could produce.
What is the check amount?
My lord, one check amount is 5 lakhs and another is 6,25,800. And in
both in the same case, in the same complaint. Same complaint.
Same complaint. And, my lord,
and how the learned session judge has modified?
My lord, lordship, in that case, lordship kindly comes to the first order of the learned judicial magistrate, page 37. According to him, my lord, lordship kindly comes the ordering portion. My lord, during the pendency of this case, my lord, 2 lakhs rupees has already been taken by the opposite party number 1, and another 5 lakh rupees. My lord, calculating that the order passed by the learned judicial magistrate in page 37, that the convicts are directed to pay 4,25,800.
Correct.
Which has been modified
my lord, by the learned session judge in their appeal to the effect that no, he has to pay.
In their appeal.
In their appeal, they prefer.
So you are appealing for the whom?
My lord, I am appealing for the accused. My lord, this is the direction of the first, my lord, the trial court.
So you are not, you are not.
I will pay. I will pay.
Okay.
But they are aggrieved with that. They went for the appeal, and in the order passed in the appeal, my lord, that order of the judicial magistrate has been modified. I am aggrieved by that. Because in the meantime, they have taken money from me.
Where is the order of the modification?
The certified copy.
Yes.
The last part of last page. Second last page.
That's why you are not annexing the second one. Total 9 pages, na? But you annex only 5 pages of the session judge order. You annex only 5 pages out of 9 pages.
That's a certified copy.
Certified copy, but originally it's only 5 pages there, madam.
Lordship, kindly go through this one. Just take it. It has been missed, my lord. Last 4 pages have been missed, my lord. I am liberty may kindly be given, my lord. I am annexing this. My lord, lordship kindly comes to page 8. My lord, these 4 pages have been left. My lord, I'm extremely sorry.
Yes,
for
yes,
that.
yes.
My lord, lordship kindly comes to page 8.
Yes.
The respondent, namely Paritosh Jaiswal and the Raj Devanti Export Private Limited, the convicts are directed to pay 8,25,800, not taking into consideration of earlier 5 lakhs and plus 2 lakhs, which have been, my lord, given in the my lord during the course of the trial.
Where is the decision? Where is the yes enhanced? The London district judge, session judge is enhanced.
Yes.
Where is the decision? Or where is the reason given that?
Lordship, page 7, lordship kindly comes.
Page 7.
The earlier page, my lord, of the said impugned order judgment.
Earlier page that 6, 7, yes.
Mala, taking into consideration of that 5 lakhs which has been given by the petitioner.
Yeah, where is that? Where is the reason he has?
During cross-examination, logically comes to page 6.
Yes.
During cross-examination of PW1, who happens to be the power of attorney holder of the appellant, admitted that previous check amounting of rupees 5 lakhs was cleared from the same account, but it does not mean that said 5 lakh was a check amount which has been bounced, i.e. check number 709613. The learned court below failed to appreciate that if a check of a similar amount, i.e. rupees 5 lakhs, if already been credited, why the respondent would hand over the same amount of the check again to the appellant if the payment has already been made. During the cross-examination of PW1, no question has been put to the PW1 that said 5 lakhs has been cleared from the same amount is that of impugned check of rupees 5 lakhs, nor there is a suggestion that said impugned amount of the first check of rupees 5. My lord, the learned appellate court has said that 5 lakhs amount is another transaction.
Correct.
That is not in respect of these 5 lakhs and 6 lakhs.
Correct.
So that will not be taken into the considerations with this amount. So, my lord, that 5 lakhs has not been taken into the consideration while passing this order. So my lord, my submissions before your lordship is.
But you have not put the question ki 5 lakhs has been paid by check number so and so. That's why where is your cross examination? That's why the session judge has taken during the cross examination of PW1. No question has been put to PW1 that this said 5 lakhs has been cleared.
Regarding 5, yes,
So if
your
you have
lordship.
not taken
But
the defense.
in the cross examinations, lordship will see, my lord, that they could not produce any document, my lord, showing that the petitioner has instructed him to deposit the check.
That is not necessary.
My lord, that was a.
Madam, in the 138 case, you know, nowadays it is a presumption. You have admitted the signature, you have admitted the issuance of the check. Even in the writing and the figures is of the other writing also, it cannot. Presumption is if you have admitted the signature and issuance of the check. That is a presumption. That presumption is to rebut by the accused only, not by the complainant is to be proved.
That is because my
That you have not rebutted because you have not put the question that the 5 lakh rupees is.
In my cross examinations, lordship kindly admit this appeal, admit these revisions, my lord. I will show through the cross examination that these questions has been put where, my lord, they could not satisfy the learned court by their depositions that they have deposited those checks because those checks are the my lord has deposited as a security security deposit.
So and so appearing for the petitioner. The petitioner has filed the present revisional application against the order passed by the learned additional session judge, fast track court, Siliguri, dated. What is the date?
My lord,
Dated.
Date lordship 3rd of February 2024.
Dated 3rd of February 2024. 3rd of February 2024. When you file the revision, limitation 29th April. Okay. 20 you will see. क्या बोला? No, this is dated.
No, my lord, taking into considerations of the date of my lord applications of the
Dated 3rd February.
Yes, my lord, the judgment and order dated 3rd February 2024.
2024. Full stop. The full stop. The initially during the trial the learned judicial magistrate first court Siliguri had passed the judgment directing the accused persons to pay an amount of rupees 4,25,800 to the complainant. Being agreed by the said order of conviction, the complainant has filed an appeal before the learned session judge, additional session judge, fast track court, and the learned additional session judge fast track court had modified the judgment by directing the petitioner to pay rupees 8,25,800 instead of rupees 4,25,800. Full stop. The counsel for the petitioner submitted that the learned judge, while modifying the judgment, failed to consider the evidence of the witnesses. Full stop. Consider the submission made by the counsel for the petitioner. This court find that the sufficient cause has been shown. Accordingly, criminal division number so and so is admitted. The judgment passed by the learned additional session judge, first court, fast track court, Siliguri is straight. The petition is directed to issue notice upon the respondents. List the matter before the next check.
Grateful. Lordship, a liberty may kindly be given to that 3 pages.
It is fine from the record that page number 6, 7, 8, and 9 of the original certified copy of the impugn order impugn judgment is not enclosed, the petitioner is given liberty to enclose the original certified copy of the page number 6, 7, 8, and 9.
Great, extremely great.
Yes. Any password, madam, is there? No. Page 25?
But after the petition.
Yes.
My lord, the opposite party, my lord, wife, my lord, filed a, my lord, application under section 125 of the Code of Criminal Procedure. My lord, in connection with that application, my lord, the learned magistrate, my lord, page 13, the impugned order, my lord, was pleased to, my lord, pass an order, my lord, page 13, my lord.
125 CRPC.
125 CRPC, my lord, maintenance. My lord, 8,000, my lord, the learned magistrate was pleased to order 8,000 per month maintenance.
You are for the wife?
Yes,
Husband.
I'm the husband. Husband. My lord, thereafter, my lord, the impugned order in this revisional application is the last order, my lord, order dated 3rd of March 2023. That is the last annexure.
Yes.
So, my lord, a mis-execution case was filed by the wife, opposite party. My lord, my contention is that, my lord, during the subsistence of the, my lord, the application under section 125, my lord, 498 allegation was lost by the wife. My lord, with regard to that prosecution case, my lord, kindly come to page 22. That is the judgment passed by the learned court below, whereon, my lord, the learned court below was pleased to observe that, my lord, with regard to the allegation of 498A, the petitioner has been, my lord, acquitted.
Correct.
And, my lord, observing that, my lord, that during the subsistence of, my lord, the first marriage, the opposite party wife, my lord, remarried. Your lordship will find from page 34 and the internal page 12 of the said judgment, my lord. Page 34 and, my lord, internal page 12. That is the second paragraph, my lord, the scrutiny of the independent witness and concealment of
the concealment of the fact the victim lady with regard to her second marriage conveys negative impact, so the case has been prosecution.
Yes.
Okay.
My lord, my contention is that, my lord, kindly have a look on, my lord, section 125.
So what is your contention? Then
yes, my lord, the contention is that, my lord, under section 125, my lord, when, my lord,
125 judgment is passed, final
yes,
order is passed.
Final order has been passed.
Correct. Directing you to pay rupees 8,000.
8,000.
Then
thereafter there was a delay laches.
Whatever it may be.
Having
So
been agreed.
after the judgment of this acquittal, wherein the court has held that the wife has conducted the second marriage.
Yes.
Correct. Have you filed any application under 128 or 127 for
127, my lord. 127.
Have you filed an application for the modification of the or
No, my lord, that has not been
done? Then, unless and until that has not been modified, how you can say that I will not pay?
Because, my lord, these, my lord, the mis-execution case
maybe
is not maintainable, my lord.
Why?
My lord, considering, my lord, the aspect that during the subsistence of the first marriage, my lord, she remarried.
Maybe,
and
but the order of the maintenance is staring in your face unless and until that has not been modified. Yes.
My lord, section 1
execution case is a part of the main case.
That I'm telling, because that
is altered.
miscellaneous execution is of the main order.
Yes.
The main order is to be executed.
It originates from the main.
So you have not filed any application for modification under 127. You are taking into consideration, you have to file an application for recalling or variation, whatever it is.
Alteration in allowances.
My lord, I pray for only one accommodation, my lord.
But kindly keep the matter tomorrow, my lord. I have to take some instruction from my client that whether any application with regard to section 127 has been filed, whether it is pending or not.
And that too, even pending also, unless and until the 127 is not decided, you are bound by the original order.
Lordship.
You are bound by the original order. As like the son or daughter. Son attained the majority.
Yes.
But you cannot say I not pay unless and until it has to be modified.
But 100, 125 is very clear and clean and clear. That,
that is clear.
Yes.
That is with regard to, see, at the time of evidence of 125, you have not proved with regard to the second marriage.
Yes.
And the court has passed an order.
That has been proved, my lord, during the trial of
subsequently.
Yes.
So immediately you have not taken any steps under 127.
Showing that order.
Kindly keep the matter tomorrow.
Not tomorrow, next week.
Next week.
21st is the
21st.
So appearing for the petition, so appearing for the opposite party. As per the prayer made by the counsel for the petition, release the matter on 21st of May.
I am grateful.
গাড়ি ছিল তোরা কি গাড়ি ছিল এখন না লাগে খারাপ হলে আমি বিদেশি গাড়ি
আমি বলছি এভরিথিং ইজ ফর
তোমার দিদি কারণ দুই নম্বরের ম্যাটারে যেটা ডিসপোজাল হলো সিডিটা কিন্তু থাকলো, সার্টিফাইড কপি সিডিটা থাকলো। 2 নম্বর ম্যাটার যেটা সাহেব ডিসপোজাল করলো ওটা সিডিটা থাকলো, সার্টিফাইড কপি কালকে দিলেও হবে, কোনো অসুবিধা নেই। না কোনো অসুবিধা নেই, পরে দিল সাহেব ওটা সই করার সময় চেক করতে পারে। কালকে দিল থাকলে থাক, কোনো অসুবিধা, যদি রিটার্ন করতে কালকে দিল সিগনেচার টিগনেচার ওই যেটা 60 লাখ টাকা 80 লাখ টাকার গল্প। হ্যাঁ ওটাই
এটা একটা বাকি তুমি ক্রসিং তুমি একটা লাইন বানাওনি,
এখন নেগোশিয়েট করে দিন। এখন নেগোশিয়েট করবে নইলে আমার বেটিং শুটিং টাকা দিলাম কেস এখন ওরা পাশে র্যাঙ্ক করে ওরা পাশে ভালো হচ্ছে না। কলেজ পড়ে আছে আরে বেশি প্রসাদ ছিল যখন কত বছর ধরে চলবে ওটার মামলা শেষ হতে চলবে। হ্যাঁ বলো কেন সেকেন্ড করতে পারে কেন হয়ে গেছে এই যাবি খাবি কিছু এই এক দাদা আইটেম নাম্বার 20 কি 21 রাখছে 21 হ্যাঁ আবার সবকিছুতে 21 সাহেব 21 সব ক্রিমিনাল মামলা সত্যি সব 21 আমি জানি 21
Last week.
Monday. Or Tuesday.
Any matrix fix? Especially fixed matrix when? When it is fixed, especially fixed matters. Which date it is fixed? 20? At what time? 20th? 20th is Monday, na? And you said Monday, Tuesday? 21st is also fixed. Especially fixed. The last one. Yes, Mr. They have not brought the CD.
And one of the irony is when the other day I said, you need the CD, he said, no, he's trying to buy time.
Monday.
Then will it be my Lordship's pleasure, my lord? I don't know, tick it up on my lord. Monday I can do it online.
Both days. Both time. What time? That is also.
My lord, whatever is in the CD, my lord.
Yes.
My lord, what is served upon me on 207 is all we can look into. We cannot look into anything else.
Correct, correct.
I have annexed everything on under 207.
Twenty-first is the criminal matters, no? Yes. 21st. Okay, I am fixing on Tuesday.
No, Tuesday. But I am out of the country from Monday night.
Monday?
From Monday night, I am out. If it can be taken up on Monday, Malad, just few minutes, he'll have to just show the CD. If he has got anything beyond what I have said, Malad, that's all.
Or it can be tomorrow. Tomorrow it can be.
Tomorrow.
Tomorrow?
At 2 p.m.
Tomorrow. Tomorrow it can be. No? Tomorrow at 2 p.m. Tomorrow at 2 p.m.
2 p.m.
Out of the record, I have seen it. He was previously with us. We have seen it.
But
I was
I have to, that's why.
Grateful, Mal.
Record and order. So and so appearing for the petitioner, so and so appearing for the respondent state. Full stop. Counsel for the state submit that due to some difficulties, the city could not reproduce. Let the matter appear tomorrow at 2 p.m. as specially fixed matter.
Grateful, Mal. Much obliged.
Yes, 4-5. Connect.
Grateful.
Item number 26.
Yeah, for the petitioner. The issue is very short.
And for the state lordship.
The issue is very short, lordship. The issue is this, lordship, the pendant during the course of trial. During the course of trial, lordship, one order was assigned with the revisional jurisdiction before the sessions court. During that revision petition was admitted and LCR was called for. Stay was not granted on merit, lordship. LCR was called for. During despite sending recurrent reminder to the learned trial court, LCR was not sent for. In the meanwhile, the learned trial court passed the impugned judgment of conviction against me, against which I have filed this application before your lordship, since I have been suffered by prejudice because during the
you are for the
petition, accused petitioner.
Accused. He has been convicted.
Convicted.
By the magistrate.
I have not challenged the conviction on merit, lordship. Only I was prejudiced. I have been prejudiced because during the pendency of the revisional application and even recurrent reminder to call for LCR, the learned trial court didn't send the LCR and pass the impugned conviction. This is how the matter has been dealt with. Lordship, LCR.
By the magistrate?
By the magistrate to the learned sessions court for disposal of the revision application. Now the revision application is still pending. Also, kindly see the order sheet.
all order sheet I have annexed. Order number 1 at page 20. 20. Revision petition was filed and it was posted for hearing on 25th of April 2022, and 25th of April it was heard and it was admitted, and subsequently interim order was not granted, Lordship. However, LCR was called for by an order dated Lordship 29th of March 2023 at page 23 of my of the order of my application.
So you preferred an appeal?
Yes,
What's
Lord.
the reason?
No, Lordship,
That is the only remedy left.
No, revision against an order. During the course of trial, one order was passed against the in an application filed by the accused person. That order was
That is your criminal revision is pending.
Yes.
For the last 1 year.
Yes.
And you are not obtained the order, the stay order.
Stay order.
And during the pendency of the revision application, before the trial judge, 3 witnesses have been examined. Your 313 has been recorded, and you have prayed for time. The court has not granted the time and passed the judgment.
Exactly.
Correct. This is the way. So this is the judgment of conviction. If you are agreed with the judgment of conviction, appeal, you have to prefer an appeal. How the revision lie?
What the revision application is still pending.
It's pre trial, Lord.
Maybe the session judge will look into the matter.
Lordship.
Either the revision and this application will be tagged together, whatever it may be.
But the problem is, Lordship, that I will lose the forum.
What?
Because the revision application was under 16.
How you lose the forum after by filing this application here? You are losing your forum on your own without going to the appeal before the session judge.
No. Session judge, a motion is still pending, Lordship. Appreciate this thing. Since the motion is pending, Lordship, without disposal of that particular motion, this impure conviction has been passed.
So where is the law? The revision is pending before the session judge. He cannot hear the appeal. Where is the law? Where is the bar?
Lordship, bar is this, Lordship. There is the issue is that there is no state jacket law in express term, Lordship. The issue is the manner of administration of justice. The manner of administration of justice and its probity warrants that when the person is paid.
You take the plea in your appeal. Take the one ground in the appeal before the session judge.
Lordship.
Challenging this order. When the judgment was passed.
Even a retrial can be given.
When
Remand, I'm seeking for only remand, not.
Can't. This court can't.
No.
Because this 227 power is there, Lordship,
Sorry.
power, because
Alternative remedy appeal, when the statutory appeal is there, how this court can enter into the
criminal justice issue, Lordship, because I have not been my petition has not been disposed of, Lordship. May I say one thing, Lordship?
Yes.
May I say one thing?
Yes.
Lordship, in a almost in a different situation, the Honorable Apex Court has dealt with this situation where the learned appellate court, without calling for LCR, had dismissed the appeal. That practice was.
I am not dismissing the revision. I am giving a liberty to prefer an appeal and in terms of the provisions of the CRPC.
That statutory appeal provision is
Correct.
there.
Correct.
Admitted fact.
Correct.
But the thing is this, Lordship, that impugned order, not this judgment, that impugned order that is pending in the motion, that is still pending.
Correct.
Now my humble submission is that if pursuant to your Lordship advice and suggestion, if I prefer a statutory appeal, that revision application will be effectual.
No. That revision application, either the judge can tag them along with the appeal or the revision application hard together.
Then remand it or rather it should.
I am disposing of this by giving the original certified copy back to you with the liberty to prefer an appeal.
And tag both the matter and here.
That I cannot. That is the discretion of the session judge. At the tag, because you make a prayer.
Plus then express it in the order. Grateful.
So appearing for the petitioner. So appearing for the state. The petitioner has preferred the present revisional application against the Where is the judgment? You are not enclose the judgment.
Yes, sir. Judgment
You are not enclose the judgment against the order and judgment passed by the London Judicial Magistrate, comma Third Court, comma Alipur in CR case number 188 of 28 2008 by convicting the petitioner to suffer imprisonment for 1 year and to pay fine of rupees 10,000, and in default to suffer further imprisonment for a further term of 1 month. Full stop. It is fine from the full stop. The petitioner has filed the present revisional application against the judgment passed by the London magistrate. This court is of Learned counsel for the petitioner submit that the petitioner has filed the present application only because already a revisional application is pending before the London district session judge, and without disposing of the said divisional application, comma, the London magistrate has passed the impugned judgment. The learned counsel for the petitioner prays that prays before this court to allow the petitioner. What is a prayer?
Prayer is that
Allow the petitioner and prays before this court by setting aside the order of conviction, remand the matter back for retrial. Police. Concerning the submission made by the counsel for the petitioner, this court find that the London magistrate has already passed the judgment by convicting the petitioner. And as such, the petitioner is having an alternative remedy of statutory appeal under the provisions of law. And thus, the revisional application is dismissed with the liberty to the petitioner to take appropriate steps, if so advised, by preferring an appeal against the impugned judgment and order. The petitioner is at liberty to take back the original certified copy of the judgment and order by replacing the Xerox copy of the same.
One more indulgence, one line maybe added, Lordship, that the competent forum should take up both the matter, Lordship. That's express. You should kindly express it, otherwise that will be a difficult one.
No, you make a prayer. You made a prayer. Session judge will take the matter. He cannot hear the both separately.
Certainly.
He cannot.
Certainly.
Item number 27.
Lordship, praying for one day acknowledgement.
Yes.
Praying
How
for
about
one
the state, my lord?
Why accommodation?
Learned counsel, due to some medical emergency, couldn't appear before your lordship.
I am appealing for different complaint.
Yes. What is the matter? Please taking. As per the prayer made by so-and-so appearing for the petitioner, so-and-so is appearing for the state respondent. As per the prayer made by the counsel for the petition, the case is adjourned. Let the matter appear before the next available.
What are the grounds? I can't understand for it. There is no ground.
That's why they are not arguing. That's why they become sick.
It's the case of 302.
Next.
Cases cannot be quashed.
Call the next matter.
Item number 28.
Yes, next. Who is appearing for the petitioner? None appears on behalf of either of the parties. No accommodation is sought for. Let the matter appear before the next available circuit bench. Next.
Item number 29.
For the statement. I'm appealing for the petitioner.
Yes.
Lordship, there was a direction to serve notice upon the
opposite party number 1 and
Director
the
sir, notice
advocate.
upon the representing the opposite party in the court below,
Yes.
as well as the
Lordship, I have-
opposite party. Have you served?
Yes, Lordship, I have served upon the opposite party. I also tried to serve upon the advocate, but the advocate refused to.
Have you served the opposite party?
Yes,
Received?
Lordship, it has not yet been received.
Track report is not there.
Track report shows item received.
On item?
Item received.
Item received by the not delivered. Give this, give this.
Stated affairs.
Sub post office has received, not delivered.
Can you take it on Monday?
So appearing for the petitioner, state,
my lord.
So appearing for the state. Police counsel for the petition submitted. The notice has been sent to the opposite party. Number?
Opposite party number 1.
Opposite party number 1, but the track report is not showing with regard to the delivery of the notice and place for time. In view of the submission made by the counsel for the petitioner, leave the matter on 21st.
21st.
Next.
I have for the state lordship.
Yes. Who is for the petitioner?
My lord, I am for the petitioner.
Yes.
Item number Anwarul Haq.
Yes.
Yes, my lord. My lord, may see the last order of Justice Gaurang Khan, my lord. My lord was pleased to. My lord, a second moment.
Petitioner stated is only on so.
Yes, my lord. My lord was pleased to opine that there was no name in the due. There is no name in the investigation. My implication was to the extent of that my vehicle was used, and vicarious liability cannot be invoked in this case because, my lord, it was with my driver. My driver was custodian to it, and the things they were, which were the contrabands they were carrying, he was exercising out of his duty without my notice. So, my lord, after these vehicles were seized, my lord, I appeared before the court and got the vehicles out through Zimmanama by furnishing a bond of rupees 10 lakhs. Subsequently, my lord, I was not informed about anything, that my name did not appear in the FIR, neither in any investigation, anywhere in the investigation. But surprising enough, my lord, my name appeared in the charge sheet they submitted under the heading of PR report. So, my lord, after knowing that my name has appeared, my lord, I approached the court below and I took bail, my lord, and the bail was granted, my lord. My lord, this is the affidavit of service which we have served. Etu halka ji, baat kaporer byapar.
Yes.
May lordship. Malay, he's a transporter, lordship. Therefore, prima facie, there is material, his vehicle was seized, he's the owner of the vehicle. Transporter is liable. There is transporter is expressly given in the section, lordship. And investigation has not been completed.
No, completed. AJP.
How the investigation is completed?
My lord, under the heading of
Stay of the
PR number.
proceeding?
Lordship?
Court has passed an stay of the proceeding? How the investigation is completed?
Have you not communicated it?
No, we have.
Order dated May, 5th March. 5th March. In view of the same, the court issue notice the respondent. There is a stay of the present proceeding.
Yes.
6th March.
5th March. Which you have referred, Justice Khan.
My lord, there is no stay in the present proceeding. The last slide.
Stay was not given.
Okay, no problem.
Stay was not
Then,
given.
where is the charge sheet?
My lord.
Charge sheet.
Yes, my lord. My lord.
Investigation completed.
My
You're
lord,
not
I
having
have-
the CD.
No, I have not received yet. Lordship.
Then?
It is their excise matter, Lordship. Excise, either they send their own counsel or they prefer sometimes.
No, but what is the role? Only it is to be seen.
The role is that, Lordship, in 46, the section,
What is the section?
46 capital A C, Lordship, is the transporter. Transporter is included in the section. He's the owner.
That's why. What is the role if the charge? Where is the charge sheet?
It is in page 16 of my petition.
Page 16 of the petition.
Page. They file it, usually they file it under the heading of PR report. Take you PR report. But my lord, my
It is not
implication
charge sheet, I
would be
think.
if
No.
something.
It is not a prosecution office. You would have to take instruction. Which page? 16. 16. এটা কোনোদিন হতে পারে না। No. This cannot be. No facts. Only some data is written. No. This cannot be a charge sheet.
What is your name?
Petition.
Huh?
Anwarul Haq, my lord.
Huh?
Anwarul Haq. My lord,
Allow me to come back with instructions.
Yes, my lord.
Charge sheet against you have been filed. Where is your name?
My lord, number 4. This, page 17, it would be 16, the continuation. 17. Number 4, Anwarul Haq.
Where? Which page?
17, my lord. 16, and the continuation of page 16 is on page 17. The second page of the PR report.
But kindly come to the. Where is the? Yes. Yes. 4. Unroll hack.
Yes.
Recovered from your vehicle.
Yes, only vehicle. Specific implication is not there, my lord.
So that's why I want to see the CD. What is the evidence?
Tuesday, madam? Tuesday?
It is
So suffering for the
Darjeeling.
Darjeeling. So
My
next
lord, then in the meantime, a stay may be given.
next circuit. So suffering for the petitioner. So suffering for the state. It is fine from the this court find that this application is to be heard after considering the case diary. Police court. The state is directed to produce this case diary of the instant case on the next date fix.
My lord, then the date is there on the mail. Then a direction may be given that we can press for a time adjournment on that day, and our adjournment application.
Next circuit.
No. Prior commencement of next circuit, there is a date. Prior
Where?
In the code below.
What is the stage of the court below? What
My
is the
lord,
stage?
probably evidence. I do not know, my lord. I do
The
not.
evidence is why are you coming for quashment?
I do not know, my lord. My lord, for that only for one day that adjournment may be given because
How this court can give adjournment of the lower court? And before the next available circuit.
My lord.
Yes, next.
Next circuit.
Hello.
Number 31, Ganesh comes in virtual.
My lord, in this matter, I'm appearing for opposite party. The bank manager.
Who is for the petitioner?
সাউন্ডটা শোনা যাচ্ছে না ওনার।
Who is for the petitioner?
সাউন্ডটা ওনা শোনা যাচ্ছে না।
Huh?
My lord, I am for the respondent, opposite party. My lord, this is an application asking for transferring one matter from 19 Metropolitan Magistrate to Jalpaiguri the reason that is mentioned is minor financial conditions as well as minor the distance. Well, in section 3.7.
Petitioner is not there. How I can hear you?
Yes, my lord, yes.
So appearing for the respondent.
Petitioner is there,
So
Lordship. Petitioner is there, Lordship.
Can I go inside? For the half an hour, who is petitioner? Nobody is responding. None appears on behalf of the petitioner. So appearing for the state. Police. Let the matter appear before the next settlement. Nobody is there.
I am praying for a short answer, my lord.
None appears on behalf of either of the party. Let the matter appear before the next. Next.
Item number 33. There are both are brother. There is a talks of settlement.
But I am appearing on behalf of the opposite.
It's appearing.
So settle.
There is talks of settlement. Can we fix this matter next week, madam?
Why next week? Yes, the matter was figured on 13.
Yes, madam. There is a both are aged person, madam. Talks of both are brother. Madam, talks of settlement is going kindly.
What is the case?
Case under conviction 326.
Huh?
326.
326. So how the compound will?
Both are brother.
326 1 year.
Both are brother, madam. Next week, madam. Kindly.
See, 326 1 year.
Next week, madam. Who is it person, madam? More than 70 years, madam.
So what can be done?
Madam, next week talks of settlement is going on, madam. Talks on a 326.
Talks of settlement. Sons appearing for the petitioner, sons appearing for the state. As per the prayer made by the counsel for the petitioner, let the matter appear on 21st. Yes, next.
Item number 32.
So 32 is over 33. Which matter it is?
Okay. No, I was appearing in item number 32.
32 is over. Next circuit.
32. Lord, due to technical glitch, I could not, Lord, appear, Lord. Can it be only not to them, Lord?
34. Yes.
Lord, due to technical glitch, Lord, I could not enter, Lord. Kindly make it not today. I'm not troubling a lot.
Next circuit. Next circuit.
No, Lord. Lord, there is some urgency, Lord. 498 proceedings. But kindly make it not today. I'll be appearing tomorrow, Lord.
Which one?
32.
21st.
Obliged.
34. Yes.
I'm on behalf of the respondent number 2.
What? Trial?
In the year 2022, I have handled complaint FIR in the latest
What is the case of under section? Where is the charge sheet? What is the case?
417, 420 and 376.
420?
420 and 376 of the
376.
Expeditious trial.
You are for the victim.
I am the victim.
What the victim?
Petitioner granted bail, Lordship. And
You are on bail.
I'm for the statement.
How many witnesses as per the charge sheet? What is the stage before now?
That's what forwarded to the session judgment, he is not being charged.
The accused is on bail, direct to appear before the additional session judge, Mata Bhanga,
5th of June is fixed for, it was fixed for charge.
for charge. How many? Sole accused? Sole accused?
Stolen.
Sujay Roy. How many witnesses? You have a charge sheet? How many witnesses? Five witnesses only?
Total 5 witnesses are there.
Yes. How soon? You are from the state. How
Well,
soon?
it's better if it is done quickly. There's a chance 5 witnesses are there.
That's
It
fine.
is better for the OP number 2 also. As soon as it gets, well, a
You are on-
reasonable time may be given, Malo, so that the trial court can.
So and so appearing for the petitioner, who is the victim in the present case. Full stop. The victim has filed the present application, praying for expeditious disposal of the case pending before the Leonard Additional Sessions Judge, Mata Bhanga, being. What is the case number? No, GR case will not be, not the special, it may be Sessions case, SC case, MTB SC, MTB Sessions case number 169 of 2023, within bracket, State versus Sujay Roy. Sujay Roy. It is fine from the record. Only 5 witnesses have been cited in the charge sheet. Charge sheet, full stop. Consider the submission made by the counsel for the petitioner, comma, state and the respondent, the Leonard Additional Session Judge, Mata Bhanga, is directed to dispose of the MTB Sessions case number 169 2023 within a period of how much? 6 months? 1 or 1 year?
That's 1 year.
Within, preferably within a period of 6 months from the date of receipt of the copy. CRR senses disposal.
Okay, full action.
Yes.
In this case, the petitioner was apprehended and arrested at Patnoda Airport. 20 kg of Gaza.
Very good. Then
Experience and the SARS, all was conducted by the security manager of Inter Global Aviation Limited, Indigo, Bangladesh. As per section 43 of Indian Act, the order and Sindar of marriage in public place
any officer of any department mentioned in section as per section 42 and 41, the empowered officer, only the empowered officer of the central government and state government, the power. So this person who conduct the search, that arrest, all the empowered.
Yes.
On the same ground, let us say not empowered officer conducts a search and arrest the same was the individual which is the copy of this incident of
Where from you got? Indian Kanun?
India Kanun.
they are Supreme Court exit also the same.
Yes. That's all.
No, considering the judgment of state of Punjab versus Banjur Singh in 1994 worship, another aspect worship, in this case, the sample which was taken to the witnesses was not produced before the magistrate. No inventory or before inventory, the sample was sent to the witnesses. And in this regard, worship, 2024 worship, various general worship, visual that trial worship, non-compliance of section 53 worship. Till number 10, ban number 15.
Page?
Page number 10, ban number 16.
Of which order?
YouTube alias Asif versus King.
Correct. Page number?
Page number 10, ban number 16.
Yes. Yes. Yes, sir.
Complete. May it please, Your Honor. As per the submission of my brother colleague, it seems that if any offense has been committed in presence of any other person not designated officer, so nothing can be done. Lordship, I humbly submit, subject to be corrected by your Lordship, this is not the intention of the legislature. First, regarding the inventory portion, I take your Lordship, this is the inventory certificate issued by the magistrate.
Yes.
So inventory was prepared. Now, Lordship, regarding section 43 NDPS Act, what he was submitting. Lordship, kindly sees section 43 of the NDPS Act.
Yeah, you the NDPS.
Yes. Section
Yes.
43, Lordship, is the power of seizure and arrest in public places. What he says,
it says that any officer of any of the departments mentioned in section 42 may. Now section 42 is relevant because the departments are there. Section 42, if your lordship sees, power to entry, a power of entry, search, seizure and arrest without warrant or authorization. Now here lordship it says regarding in which circumstances this entry, search, seizure are there. Lordship sees the first subsection 1, any such officer being an officer superior to the rank of peon or sepoy constable such and such, lordship is by the state government, if he has reason to believe from personal knowledge or information given by any person and taken down in writing that any narcotic drugs or psychotropic substance or controlled substance in respect of which an offence punishable under this act has been committed, or any documents or other articles which may furnish evidence of the commission of such offence, or any illegally acquired property, or any document or other articles which may be furnished evidence of holding any illegal acquired property which is liable for seizure or freezing or forfeiture under chapter 5A of this act is kept or concealed in any building, conveyance or enclosed space. In a case where those are kept concealed in any building, conveyance or enclosed space, and if that information is received by any person authorized, then comes the question of 42 and 43. I take aside the entire NDPS Act. I pray with your lordship to kindly seize 43 of CRPC. Section 41, lordship knows better than me, is the provision of arrest and who can arrest.
Yes.
The police can arrest under 41. Under 43, arrest by private person or procedure and procedure of such arrest. Now, private person, A1, any private person may arrest or cause to be arrested any person who in his presence commits a non-bailable and cognizable offence. Then what is the procedure? And any proclaimed offender, and without unnecessary delay shall make over or cause to be made over any person so arrested to a police officer, or in absence of a police officer take such person or cause him to be taken in custody of the nearest police officers. So if any cognizable and non-bailable offence is committed in presence of any private individual, he can arrest that person, and without delay he has to forward the person to the police officer.
Yes.
Now lordship kindly sees page 2 of the case diary.
Yes.
Is the written complaint lodged by the complainant, that is security officer, and sees what happened, lordship. While he was checking in the X-ray, it was found that his baggage was carrying these narcotics. So what will do? Will he sit and lie? No. What he did, he detained the person, informed to the CISF, and took the person to the nearest police officer and lodged this complaint. Now lordship sees page 23, memo of arrest. Who arrested the? He has detained, but who has arrested is the police, lordship. Now page 26 is a seizure.
Where is the place of arrest?
Place of arrest, lordship, is at the PS. He has taken at 43. He has to take the officer to the police. He has. Now kindly sees page 26. This is a list.
Yes.
Prepared by police. Now sees lordship kindly sees from whom seized. The complainant, he took that person. His name is also there. Signature is also there, and the articles to the police as per 43.
But how the 26 can be taken as a seizure memo? See.
Initial seizure was done by.
I totally agree. Mr. Kapil Dev Singh has already taken the possession of the property, made the seizure memo, took the signature of the witnesses, taken the custody of the
He has done certain overact. I may admit. He has done certain overact. But if you brush aside
No,
those
that-
person,
if it is done,
Lordship.
then how your 26 will?
He has taken those articles, the accused person to the police as per 43 he can.
So that is in the hand of the complainant. The seizure is in the hand of the
Hand of the
complainant. If it is in the hand of the complainant, how this seizure is sustained?
No, let's say from whom seized. Both the names are there.
No. Kapil Dev Singh is the witness.
Witness, he has taken, and the name of the accused is also there.
Yes, accused from accused.
From accused.
How it will be taken from? How it can be seized from the accused? It already the possession lost.
But what he ought to have done is to detain the offender and call the police.
That is
I understand. He has done certain overact, Lordship. My submission is that he has done certain overact.
Yes. Next.
That I also know that. But Lordship, then forwarding before 21 is by the police. Police has submitted charge sheet. Now it's press for on 4/6/2024 for PW1. So this is the stage.
Charge framed. Charge framed.
Charge framed. Overact is there.
Sir, and sir, P2 also appeals and memo of appeals and also prepared by that of the judge. And also regarding inventory, Lordship, kindly Lordship. Annexure P1, Lordship.
Page.
P1, Lordship, petition, Lordship. This is a certificate of correctness. Lordship, the date was 11 January 2023, Lordship.
P1.
P7, P5, Lordship, P5.
P5.
Annexure P5.
কত নম্বর? No.
Yes.
P5.
11 January 2023 on the correctness of inventory.
And photographs.
Yes, Lordship.
Hmm.
And Lordship, annexure P7, Lordship, Lordship. The report of the state drug control and research laboratory, they received the sample on 24th December prior to inventory, Lordship. Annexure P7, Lordship. Total non-compliance of 52 Lordship.
Where the receipt, date of receipt 27/12. And this is the certificate issued by the magistrate.
The sample which was corrected before the magistrate was not sent to the FSL. The same which was sample which was at the time of seizure, Lordship.
Where is your inventory?
Inventory, Lordship, page 143. That is page 28 of their petition. Same there.
Page 123.
143.
133.
143. The certificate of inventory. The certificate was issued on 11 January 2023. But
that's why I'm asking 143. Itna. Crime number 397.
Lordship.
Crime number 397.
397 of the 2003.
No, crime number. Case number 586.
Case number 586.
586. And in this case is 586.
586. Bagdogra Police Station 586.
So your magistrate paragraph says being request by the so and so dated with order date 29/12/2020.
29/12. We have placed those articles on 22/12.
And how the article reached to the CFSL on 24/12/2020.
Lordship,
come to the page 29.
I'm switching off the thing. The latest judgment of the Supreme Court says those are nothing but trash of paper.
Who is that?
In many of the cases, Lordship knows better than me because what I am feeling, Lordship has felt that these things are happening. After seizure, The state was sent this sample and then the rest amount goes to for the bill. So uncertified samples are sent for inventory for the testing, and Supreme Court latest judgment is that report is nothing but a test.
Correct.
I guess my case, but my submission to do.
So and so appearing for the petitioner. So and so appearing for the estate. The petitioner has filed the present application being CRR 162 of 2024. Praying for 2024 under section 482 of the Code of Criminal Procedure, 1973. Praying for quashing of the proceeding of Bagdogra Police Station case number 586 of 2022, dated 18/12/2022, under section 20 within bracket small b within bracket II within bracket small c of NDPS Act, corresponding to CR NDPS number 139 of 2022, pending before the Learned Special Court NDPS Act at Siliguri. Full stop. The petitioner says that the assistant manager security Indigo Airlines has made the alleged seizure on 18 December 2022 at the Indigo at the flight at Indigo X-BIS within bracket number 1 at Bagdogra Airport. At Bagdogra Airport. Full stop. After the petitioner the क्या बोला? Bagdogra Airport, and also taken and also retain the petitioner, and the petitioner along with the alleged seizure were brought to the Bagdogra police station, and on the basis of the complaint made by the assistant manager security Indigo, namely Kapil Dev Singh, PS, the police has registered, and where is the FIR? Registered an FIR being number 586 of 2022, dated 18/12/2022, under section 20 within bracket small b within bracket II within bracket c of the NDPS Act against the petitioner. And the petitioner was arrested by the police of PS Bagdogra at the police station. At the police, where is the arrest memo? At PS Bagdogra. As PS Bagdogra on 12th August, no, 18/12/2022 at 23:50 hours. Full stop. The full stop. The petitioner submits that. The petitioner submits that the LS seizure made by the security officer, that is the complainant, a security officer of the Indigo flight, that is the complainant, is not a seizure under the provision of section 43 of the NDPS Act. Full stop. He further submit that the police has also not conducted the inventory in provisions of section 53, 52A of the NDPS Act. Full stop. The petitioner submit that the counsel for the petitioner submit that the petitioner has been falsely implicated in the instant case and the police has not followed the procedure as provided under the NDPS Act. And he prays for full stop. He also relied upon the judgment reported judgment. What is the citation? The judgment in the case of Roy Varoy VD V full stop D full stop versus State of Kerala dated 10th September 2000, wherein the Honorable Supreme Court held that the search made by the empowered officer on prior information without informing the person of his right that if he so requires, he shall be taken before the gazetted officer or a magistrate or search, and in case he so opted, failure to conduct his search before the gazetted officer or a magistrate. No. This one.
The citation is not here. About 2008 SCC 590.
2008 SCC
590.
590.
Particularly.
Number नाम लिखे 2008 so and submitted that arrest and search made by the officer not empowered or authorized in violation of section 41 and 42 is per se illegal and the trial would vitiate. Full stop. The learned counsel for the petitioner further relied upon the judgment reported in 2023 live law SC 570 within bracket Samarjit Singh versus State of Punjab and submitted that upon seizure of the contraband, the same has to be forwarded either to the officer in charge of the nearest police station or to the officer empowered under section 53 who shall prepare an inventory as stipulated in the said provision and make an application to the magistrate for the purpose of correctness of inventory, but in the present case, no inventory has been made. Learned counsel for the petitioner further relied upon the judgment passed in Yusuf alias Asif versus State, passed in criminal appeal number 3191 of 2023 within bracket arising out of SLP criminal number 3010 of 2023 dated 13th October 2023, wherein the Honorable Supreme Court held that in the absence of any material on record to establish that the samples of the seized contraband were drawn in the presence of the magistrate and the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the seized contraband and the sample drawn therefrom would not be valid piece of primary evidence in the trial. Full stop. He prayed that the police authority has not followed any of the provisions of the NDPS Act, and as such, the FIR and the charge sheet is required to be quashed. Subpara. Per contra, learned advocate appearing for the state submitted that as per section 43, any officer of the department can make the seizure, and in the present case, the complainant, who is the officer, that is the security officer of the Indigo Airlines, and he found the contraband when the materials was scanning through the scan machine, and accordingly he has made the seizure and detained the petitioner, and subsequently he was brought to the police station and made a complaint, and on the basis of the complaint the police has initiated the FIR, and as such it cannot be said the seizure made by the complainant is illegal. He further submitted that after the arrest by the police, and submitted that after initiation of the FIR on the basis of the complaint of the security officer of the Indigo Airlines, the police has taken the custody of the narcotics and made a fresh seizure memo by making the complainant has witness to the said seizure memo, and also arrested the petitioner by preparing the custody memo, and as such this part of act of the police authority cannot be said to be an illegal. Full stop. He submitted that after the seizure was made, the investigating officer has made a prayer before the learned special judge NDPS court for making an inventory, and accordingly learned special judge requested the learned magistrate for making inventory of the narcotics, and accordingly the inventory was made, and as such the submission made by the counsel for the petitioner that the inventory has not been made cannot be sustained. Full stop. At the full stop. Learned counsel for the petitioner further submit that the police has completed the investigation, filed charge sheet. Full stop. The charge has already been framed and the case is at the stage of evidence, and as such a direction can be passed upon the learned special judge for expedite the trial of the matter. Full stop. Had the learned counsel for the respective parties perused the materials on record. Admittedly, the complainant has made the seizure of the alleged narcotics and detained the petitioner. Thereafter, detained the petitioner, and the complainant has brought the petitioner and the narcotics to the police station. After going through the city, this court astonished to say that the police had made a fresh seizure list at 22:15 hours to 23:45 hours with regard to the said narcotics from the hand of the petitioner, though as per the seizure memo prepared by the complainant, the alleged narcotics has already taken possession by the complainant at the Bagdogra airport itself, and as such the seizure memo prepared by the investigating officer at the police of PS Bagdogra cannot be said to be illegal. Full stop. This court further noticed that after the making of the fresh seizure, comma, the investigating officer made a prayer before the court for making an inventory on, where is the application? Page 143.
143. 143 is the certificate.
Certificate. That 143, na? Made an application before the special judge for making an inventory, and accordingly, by an order dated 29/12/2022, and according the learned session judge has directed the learned judicial magistrate first court Siliguri to make an inventory. Accordingly, on 11 January 2023, the investigating officer has produced all the alamats, all the seized article before the London magistrate for making inventory, and accordingly, the London magistrate had made the inventory, has certified the inventory made by the police authority by way of photographs and making the samples of the seized alamats. Full stop. This court further astonished to see that as per the certification, as per the certificate issued by the Judicial Magistrate First Court, Siliguri, as per the order passed by the Learned Special Judge Poxo NDPS Court, dated 29/12/2022, the investigating officer has produced the seized alamat, seized articles, not alamats, seized articles before the magistrate for correctness of inventory. But in contrary, which page? But in contrary, it is found that the investigating officer had already sent the narcotics to the State Drugs Control and Research Laboratory, which was received by the said laboratory on 27/12/2022. This court failed to understand the materials was placed before the magistrate, and the Learned Session Judge and the Learned Special Judges passed an order on 29/12/2022 to place the materials before the London magistrate for certification of correctness of inventory. And on 11 January 2023, the investigating officer has placed the material before the London magistrate. But how the material was sent to the government and to the State Drugs Control and Research Laboratory on 24/12/2020. Considering the above circumstances, this court find that the total procedure adopted by the investigating agency is total violation of the provisions of either section 43 or section 53, just a minute, 52A of the said act. Full stop. The Honorable Supreme Court, in the case of Yusuf alias Asif Supra, has categorically held that in the absence of any materials on record to establish that the sample of the seized contraband were drawn in the presence of the magistrate and the inventory of the seized contraband was duly certified by the magistrate, it is apparent that the seized contraband and the sample drawn therefrom would not be valid piece of primary evidence in the trial. In this case also, the first lacuna of the prosecution, that the unauthorized officer has seized the materials. Secondly, after seizure of the material by the unauthorized person, again, the police has made the seizure at sitting at the PS. Thirdly, on the basis of the seizure, the investigating officer had made a prayer for making for certification of the inventory. But before the inventory has been made, the investigating officer has already sent the materials to the CFSL for examination. Considering all the above facts, this court find that this is the fifth case wherein this court invoked the provisions of 482 for quashing of the proceedings. Accordingly, the proceedings in connection with Bagdogra PS crime number 586 of 2022 is quashed and set aside. The petitioner is discharged from the bail bond. Deeply agree. No. I had faced so many people.
The 3 p.m. fixed matter.
Fixed matter item number 79. Yes.
But 79, I appear for the petitioner.
Yes.
Lordship, I am for the added defendant.
Ah. Yes.
On yesterday, I was in this court from 10:30 to 4:30.
Correct.
All on a sudden, this matter is fixed today. Practically, I am not in a position.
But if my learned friend has a problem, my lord, we can come to your lordship physically on the 20th.
If it is,
Subject to your lordship's
Yeah,
convenience.
yes, Mr. Yes.
if it is possible, then let the matter.
No. This court is not against any of the body. Only after going through this notice, which the demarcation is fixed at 1 p.m., taking the urgency, I have fixed a matter because the matter is fixed at 3 p.m. so that if further after hearing, that's why I asked the parties to issue the notice to all the parties so that the matter can be taken, what order is to be passed. That's why. It is not that I am going to dispose of the writ application. Only on the basis of the notice which the authorities have issued for the demarcation today, the 1 p.m. what has happened, we don't know. That's why I fixed the matter at 3 p.m. Let us see. Yes.
Milord, at 1 p.m., Milord, my instructing advocate was there. Milord, during the inspection, we had informed the parties who had come for inspection, Milord, that the matter has been brought to your lordship's kind notice and the matter is fixed today at 3 p.m. They took the notice on record and they have left, Milord, without doing or undertaking any inspection.
Okay.
And your lordship, a copy of the order, the reply was also handed over to them. They wanted that.
So, what is your submission now?
Milord, my only humble submission, I'm sorry.
Yes.
Initiation we have challenged this petition is not at all major.
Okay, now.
Scenario. If it is so urgent, let the matter be fixed tomorrow at 10:30.
No, the pleadings have been completed. Not
My lord, I appear. My lord,
let me see one by one. Who has filed the affidavit, who has not filed the affidavit. Let the matter can be solved. Correct.
My replies are with Mrs. Ghosh.
Yes, Mr. You are appearing for the
Petitioner.
writ petitioner. Who is for the state?
Mr. Shubir Shah is there, Milord, in court.
You are for the state. Have you filed the affidavit? No file. Not filed. And you are appearing for the added respondent. And you are appearing for...
I am appearing for the Heritage Commission.
Who is for the
The Heritage Commission is also before your lordship. Mr. Devru Bhattacharya.
Yes, Mr. Bhattacharya.
Yes, Milord, I am appearing for the Heritage Commission. Milord, we have prepared and Milord, we have served the copies. The only thing is, Milord, it has not been filed with your lordships, but it has been served. We have received the reply. The original affidavit, Milord, it's written with my advocate on record, and Milord, he is in hospital. Milord, that's the reason could not be filed.
We have not filed.
We can
received
both
it.
not
received the
subject
reply.
to your lordship's gracious convenience. If it comments to your lordship, we can travel to Jalpaiguri on 20th. 20th, Calcutta is uncertain, my lord. We can assist your lordship there.
Milord, the only difficulty is the 20th is my election. Milord, I stay in Howrah.
What?
So all the thing can be after 4th of June.
No, I wanted to do it before your lordship.
What is the injury? I do not know. By simple.
But who is he?
So,
I
okay,
put
okay.
this question entirely to myself, my lord. Who is my learned friend?
Okay, what? I am not going into that. So,
Very well.
with regard to the state has not filed the affidavit in opposition, state will file affidavit in opposition or not? Not necessary. And with regard to the Heritage Commission, you will.
The Heritage Commission's affidavit, my lord, we have received. My lord, the reply Mrs. Ghosh is carrying, my lord.
The reply has been filed.
You have filed.
Reply has been filed.
You have filed. And
Milord,
with regard to 2, 3.
Original is not retained with that.
So, Mr. Bhattacharya, you are appearing for the 2 and 3.
No, it is the petitioner, your lordship.
Yes, Debru Bhattacharya is appearing for 2 and
This
3.
Bhattacharya.
Oh.
Yes, and
I am appearing
who
for
is
the
the
Heritage Commission. We have served
magistrate?
them the original list.
The district magistrate,
Who is the
Mr. Saha is appearing.
District Magistrate, DM, ADM, and Chairperson, Municipality.
My lord, municipality, I do not know whether anyone is appearing.
Jalpaiguri Municipality, where he has gone. So I am fixing next circuit.
My lord, as your lordship pleases, my lord. My lord, I can come to your lordship, my lord, next week if it so comments to your lordship.
You are
I have no
welcome.
problems.
You are welcome to the Jalpaiguri, but subject if all the parties are ready, I have no problem for take the matter. But
I do not know, my lord, if everyone is agreeable, my lord, we can go next week, my lord, 20th. Mr. Bhattacharya can conduct it from
yes,
Calcutta.
Mr. Bhattacharya will cast his host. This is a constitutional right. I cannot curtail down.
My lord, the Honorable the Chief Justice, my lord, stayed in Calcutta and did not travel to Chennai. I told him, my lord, while arguing the matter, that my lord, my lord is sitting here, my lord, Chennai, the entire election is taking place there on a single day. But I could not go, his lordship said.
Okay.
Anyway, my lord, your lordship keeps it, my lord, next circuit. And let it be recorded that the state does not intend to use an affidavit.
Now they are telling that they are not affirmed. They are not affirmed. Yes, Mr. Debru, how soon you can file and how you circulate the affidavit?
Milord, I have already circulated. We have received the reply. Only thing, the original affirmed copy is retained with the advocate. Milord, he is today, Milord, he is admitted in hospital.
But
we could not send it.
But you are not served to the additional added respondent.
Milord, that we have not served. We have only served the petitioner because it's in.
That is the complaint he is making. That is the complaint he is making.
Milord, he can write to give us the address. We can serve him. Milord, if he write to us,
Debru, I'll share the address with you. You please share it with him.
Yes, sir.
I'll share the address
Please,
with you.
give the email to them. They will serve to you. Mr. Biswarup Bhattacharya, London advocate appearing for the petitioner. Mr. Mr. Saha, Mr. Subir Kumar Saha, London advocate appearing for the state respondent. Mr. Subrata Goswami, London advocate appearing for the respondent number 2 and 3. Mr. Narendra Nath Das, London advocate appearing for the intervener. And Mr. Debru Banerjee appearing for the. You are for the.
Milord, I am Debru Bhattacharya. Milord, I am for the respondent number 2 and 3, along with Mr. Subrata Goswami, who is
along with them. Full stop. The Mr. Debru Bhattacharya, London advocate appearing for the respondent number 2 and 3. Submit that. He has prepared the affidavit in opposition and also circulated to all the parties, but it could not be filed. He will file the same before the next date fix. Full stop. Mr. Biswarup Bhattacharya, an advocate appearing for the petitioner, has already filed affidavit in reply to the affidavit in opposition filed by the respondent number 2 and 3. Yes.
As well as the added respondent. Milord, I have also filed my reply to the added respondent's affidavit.
And Mr. Bhattacharya also filed the affidavit in reply to the affidavit in opposition filed by
the added respondent.
Full stop. Mr. Debru Bhattacharya, an advocate appearing for the respondent number 2 and 3, is directed to serve the copy to the state respondent as well as the added respondent within a week from date. In view of the above, let the matter appear before the Next available circuit bench. Great. Under the heading hearing.
I'm grateful to your lordship.
Grateful, your lordship.
Grateful.
Grateful to your lordship.
Yes, thank you. Yes, who is for the petitioner? 36.
I have challenged the appeal proceeding on a support that is in a same transaction, there are case and cross cases which record to be investigated.
Please. Silent. Made it silent in the courtroom. Okay.
I have challenged the appeal proceeding on a particular premise that when law has mandated that the case and cross cases to be investigated by the common investigator and to be tried jointly. So in this fact of case, it has not been done. That's why I have challenged this case. The case is just like that.
So what is your prayer?
Prayer is that let the
Taking up both the case.
taking of both the case first of all, my case has not been investigated by the common investigator. First of all, that need to be ensured first. Then tag up both the case.
Common investigation.
Common investigator. Common investigator.
I don't think so.
And joint trial.
Joint trial is a 210, I think so.
Yes.
210, na?
Yes.
Your case is on both are the police case.
Police case.
Both are police
Both are
case.
police case.
It cannot. It is the complaint case and the police case.
No. That's the Honorable Supreme Court's judgment and the guideline says that both the police.
That's correct. That's correct. Yes.
So the motion says, should I come back with service notice?
Serve the notice. And not serve the notice.
No. The first motion was. Meanwhile,
so appearing for the petitioner. Police. This court find that this application is to be heard in presence of the opposite party. Accordingly, the petition director served the copy of the application along with the documents to the opposite party or parties?
Parties.
Opposite parties. This is the matter on 21st. Can be done or next circuit?
21st, it can be done also.
Let the matter appear on 21st.
21st, 22nd.
21st.
21st.
Next.
Interim order, if the.
Come on that day. Next.
Item number 37, I am on behalf of the petitioner, my lord.
Yes.
I filed this criminal revision, my lord, for quashing of the charge sheet and the proceeding of the lower court, my lord. This is a case which has been initiated under section 447, 427, 506, 34 of the Indian Penal Code, my lord. If your lordship comes to page number 16, is the FIR, my lord.
Yes.
It's a land dispute, my lord. It's written in the FIR. May I read the FIR, my lord?
Yes.
It states, I, Arati Sarkar, that to inform you that my husband, Sri late Manoranjan Sarkar, bought a land measuring about 10 decimal or 6 katha from Sri Gopal Chhetri. Why deed number this? All these years, the land was under my control and there was peace. But suddenly now Sri Kormal Orao, he happens to be the father of the petitioner. And Sri Shankar Orao, he is the petitioner, my lord. After my husband dead, these people now mistreats me and also uses bad words at me. Whenever I step on my land mentioned above, they also remove all the wooden stick which I use as boundary of my land and also not allow for any construction work. These people also scares us, saying they will beat us if we ever step into that land. This is the allegation, my lord. Now, my lord, the father of the petitioner happens to be the owner of 2 bighas of land. Now, I have annexed the Khotiyan, my lord. That's in page number 18. He was a Bargada since 1375. Thereafter, they have purchased the land and they have also the recorded.
Who purchased?
The father of the petitioner, my lord. That's the Khotiyan, my lord, in page number 19 and 20. Now, my lord, the father of the petitioner in the year 2015, that's in page number 21.
Yes.
gave a complaint that it was the de facto complainant and her husband who was trying to encroach into the land of the father of the petitioner, my lord. Thereafter, in the year 2021, again, that's in page number 22, my lord.
Yes.
They happen to be an SC/ST, my lord, and they were trying to ousted them from their own land, my lord.
Who are SC/ST? Complainant?
No, the accused persons.
Accused persons are
Yes, my
SC/ST.
lord.
Yes.
The accused persons are SC/ST.
Hmm.
And they were being tried to be ousted from their own land, my lord. In that regard, 2021, the FIR was given, but no police action was taken, my lord. 24, they were even threatened with dire consequences. No action taken, my lord. Subsequently, the de facto complainant's father has even given a complaint to all Adivasi Shuchar Association, my lord. They have also given a complaint to Additional Superintendent of Police regarding that their land is being encroached by this de facto complainant and other people, my lord. And at the end, my lord, in the year after they lodged their complaint, this FIR was initiated. Thereafter, a counter FIR has been lodged, initiated. Now, my lord, if your lordship sees the FIR, my lord, based on which this complaint has been initiated, my lord, the FIR was filed on 6/5/2022. On that day only, without even any inquiry, my lord, the case was initiated, 6/5/2022. If the formal FIR is in page number 15, my lord.
Yes, yes, I got them.
My lord. So, without any inquiry, my lord, this is a civil in nature dispute, my lord. Further, my lord, the petitioner hearing is a student, my lord. He is a PhD. He's doing PhD in geography at the present moment. On that day, that is 6/5/2022, he was giving exam in Banaras University. I have annexed the Banaras Hindu University's examination here, the paper, my lord, theory papers. That's in page number 32, my lord. Was not even present on that day, my lord. That's 32. Examination date is 7/5/2022, my lord.
Yes.
My lord. It's just a land dispute, my lord, and it has been given a criminal color, my lord.
This is the charge sheet is filed.
Charge sheet filed, my lord.
Charge sheet, what are the documents denied by the prosecution?
Nothing, my lord. Nothing.
So how the 447 is established?
They say that BLO, they have asked for a BLO report.
That's why I'm asking, with
No
regard to the 447, there should be a report either from the BLO or from the Tahsildar that your land is, this is your recorded land, you are there in occupation. Then the 447 will come.
They have written in the charge sheet.
And 427, what is the, where is the
No
447?
mischief. No mischief, my lord. No, nothing written in the FIR with regard to mischief or anything.
Yes, who is for the state?
No,
You are.
it's the first time I'm moving, my lord.
Issue notice.
Yes, my lord. Notice as your lordship.
What is the stage of the trial?
My lord, the father died, my lord, few days ago. Now it is for police report, my lord. The case will go on lingering, my lord. That's why he has filed this charge for quashing.
Father and the father of the accused.
No, father of the accused.
Petitioner.
Petitioner.
How many accused are there?
Two accused person, my lord.
Who
The
are
father,
they?
Yes.
Father died. No, only
Father
son.
died and the son has filed.
Only son now. And son was not there.
My lord.
Son was not there at the time of the
Yes, my-
incident.
Yes, my lord.
Yes. Which PS? Naxalbari. Naxalbari. Okay, next circuit.
My lord, but service is required to be done, my lord.
Wait, I am calling.
My lord, my lord.
So appearing for the petitioner. This court find that this application is to be heard in presence of the state respondent.
My lord, abstain, my lord.
Accordingly, the petition is directed to issue notice upon the respondent. After going through the record, this court find that this is the civil dispute between the parties. Though after the investigation, the police has submitted the charge sheet against the petitioners for the alleged offense under section 447, 427, 506, 50, and 34 of the IPC. But in the charge sheet, the police has not enclosed any document to prove that any document to establish that the petitioner has illegally occupied the land of the petitioner and land of the complainant, de facto complainant. This court find it, and this court find it. Petitioner has made out a prima facie, and this court find it until the hearing of the instant application, the proceeding before the learned magistrate.
My
Which court?
ACGM
Learned magistrate.
Additional Chief Judicial Magistrate.
Proceeding before the learned additional Chief Judicial Magistrate at Jalpaiguri. Being, what is the case number?
Case number is 98 of
Annexal P, Annexal
Not sure.
PS number 98 of 2022 is stayed till the disposal of the application.
I'm grateful, my lord.
Lord, I beg to appear on behalf of the petitioner. Lord, I am praying for quashing of this CR case filed by the wife, my lord, under section 498A and 34 of the IPC, my lord.
Yes. 498A.
498.
It is a love and affection. Why you wanted to quash?
My lord, marriage between the petitioner and the opposite party number 2 took place in April 2022. Thereafter, within 30 days, the opposite party number 2 left the house, took all the ornaments and belongings, Lord. Thereafter, went there and filed a CR case before the learned court of ACGM, Alipurdwar, my lord.
Who filed the CR case?
CR case was filed by the opposite party number 2, that is the wife.
Wife has filed the CR case against the husband.
Without-
Husband.
Yes, my lord.
For the offense?
Offense under section 498A and 34.
CR case.
CR case.
Yes,
Without
then-
any complaint.
Okay, then?
Without any FIR. Then process was issued under section 200. My lord, subsequently the petitioners took bail, and my lord, next date is fixed for evidence, my lord.
Next date fixed for?
Next date is fixed for.
It is a CR case.
CR case. My lord, the opposite party number 2 did not file any complaint. No FIR was there, no charge sheet, nothing. My lord, kindly takes up the complaint case filed before the learned court of ACGM, Alipurdwar, my lord. That is at page 15. No specific allegations have made out against the petitioner. That is the husband, father-in-law, and mother-in-law. My lord, page 15, running page 15 of the instant petition, my lord. The complaint, is legally married by the opposite party number 1, Abhijit Kobira. Their marriage was solemnized according to Hindu rites and customs, as ceremony situated at Cinchura Hotel near Alipurdwar, Chaupati. Lord, kindly text next page. The marriage was according to the demand of the accused person. The complaint was compelled to give huge number of ornaments, Lord. That after the marriage, the accused took the complaint to the house that is at Kollani, Nodia. My lord, on the first night of the marriage, told her that the complaint must, she must do.
What has happened to the section 12 DB Act?
Yes, my lord. DB Act is still pending, and the husband
is there any interim order?
Yes, my lord. Rupees 15,000 the petitioner is paying to the wife, my lord.
Under the DB Act?
Under the DB.
No 125?
No 125 as of now, my lord. Subsequently, my lord, one order has been passed, section 125 application has been filed, my lord. No interim order.
And what is the stage of this CR case?
CR case, my lord, I have annexed the order of the certified copy. Next date is fixed for 6th June for SR, my lord.
SR? SR?
Yes, my lord. SR.
Fixed for examination and complaint on Hajra filed. Now the record is taken up.
No specific allegations against the husband. No, my lord. If the wife was tortured in Kollani, Nodia, after going to parental home, she could file a complaint. No complaint was filed. No FIR. Then process was issued by the learned court of CJM. Thereafter, the petitioner just to harass the present petitioner, the instant CR case has been filed.
Yes.
And on every date, the petitioners have to come down from Kollani, from Nodia to Alipurdwar to attend the date of hearing. This is simply harassment and abuse of the judicial process, my lord. My lord, I brought one judge.
What your client is doing?
My lord, he is. I have to take instructions, lord.
You are up.
A private, he is working in a private company. May I
Yes.
place one judgment.
You are appearing for?
One judgment of Justice Shampad Paul. Very beautiful judgment. Deepak Chatterjee versus State of West Bengal. Kindly takes up page number 10. A lot of cases have been referred, my lord. Kindly takes up this in Kashan Kosar at Sonam versus State of Bihar. My lord, paragraph 12. Last paragraph, before we delve into a greater detail of the nature and contention of the allegation, it becomes pertinent to mention that incorporation of section 498A of PC aimed at preventing cruelty committed upon a woman by her husband-in-law by facilitating rapid state intervention. However, it is equally true that recent time matrimonial litigation has also increased significantly, and there is a greater defection and friction surrounding institution of marriage now. Now more than ever, this resulted in increased tendency of such as 498 IPC and the instruments to settle personal scores against the husband and relative. Thereafter, my lord, kindly takes up the next
What
page.
you want at this stage?
My lord, quashing of the present CR case.
Notice is to be issued, other party has to appear.
My lord, he is appearing. Notice has already been issued.
You are appearing?
Yes, my lord. Now,
Can
my
it be
lord,
caused? Can it be caused? No. Why?
One submission made by Lanet said that he has to come down from Nokia to the Jalpaiguri. They have always had a permission to make the application to transfer the case. Whatever, if he can do without to this issues.
Can I record your submission and can I pass an order for transfer?
Submission that I made.
Because you are making a submission, there is a provision for transfer. If you are ready to transfer the matter, then here in now in this application, I am passing an order. All the case be transferred to the Kolkata jurisdiction. So you have opened your submission from the transfer of the case. Yes, I have gone through. Correct.
Kindly come, the first submission they are making, there's no allegation against the husband and all the you will not kindly come to the from paragraph 4 onward. Each and every sentence is paragraph the allegation.
Can a magistrate take cognizance only on the basis of one witness in the CR case, that too at the warrant trial? Without corroborative evidence, whether the court can satisfy under 200. Where is the list of witness in your complaint?
Nothing, my lord.
Once the court start putting question,
Nothing.
then start, I am taking instruction in instruction. Unless and until the court will not put the question, your voice is high. This is the way of the drafting of the application, complaint. Where is the allegation? Where is the allegation? The police has not taken any steps against the petitioner. That's why you made a complaint. Where is the NCFIR? Where is the NCFIR? Yes. Show me. That I am not. I am asking. See, what is the natural person? What will do? You have been tortured. First, you will go to village pradhan, or you will go to your relatives. Then you go to the thana. Then you go to the SP. Then you go to the DGP. Then you come to the court. Where is all this? Where is the case you made out that you have went to the police station? Police has not recorded the statement, not chalked out an FIR, not inquire into the matter. That's why you come to the court under 200. This is one question. Second question, satisfied this court? Only on the basis of the wife evidence, without the corroborative, the court can take a cognizance under 498A. So that's why I'm asking. That is a corroborated. So 498A, okay, there will be no independent witness. There will be no independent witness, but corroborative. circumstances, where is that? Where is, whether you examined before,
Not at all examined.
page number 15. Where? Yes. Where is the list of witness?
Just after my lord, going to district Nadia, witnesses Pura Chandra Mitra, Shikhamita Ashim.
Acha, you given the name of first.
Only names have been provided.
Okay. Where is the evidence in 3 witnesses? Where is the, no, we can't. Kindly come to the cognizance order. Kindly come to the cognizance order. Original certified copy, a number is not there.
Last page, my lord. Last page. Last page. Order
Original will not be provided, it is there. You go through this. Today's fixed for examination of the complainant under 200. Hajra filed, complainant is present. Record is taken of examination and complainant on essay. Under itna. Complainant namely so-and-so has been examined. Peruse the record, statement of complaint on perusal, complainant witness opinion that the sufficient ground for proceed with the matter. How it can be? What material the magistrate has considered? Where the magistrate sent the matter to the inquiry? That's why the 200 only wife was examined and cognizance taken. That's why I'm asking. And there is no document at all. Police report or anything. What material the magistrate has considered?
Cognizance was taken.
First of all, this is their petition. I have not gone through this.
My lord, on the last occasion also they have taken time, my lord.
Last occasion, they have submission that they have filed 2 petitions. One is against the domestic violence, another is not, and another 460.
My lord, kindly produce the last order.
For this Milad, they have taken time. So that this is the Milad, there is. This is the reason, Milad. Last occasion, Milad, they are supposed to be those 3 matters all together.
That is correct. Settle it.
There is also, my lord, non-compliance of section 202, my lord.
Husband, wife. What is your intention? Huh? To take divorce. You are not ready to give the divorce.
My lord, I have to take it.
Take instruction, go for the mutual divorce, settle it. All matters.
As of now, my lord, I have taken instruction, my lord. I am not inclined to give divorce, my lord. My lord, I want to reside with the wife, my lord.
Wow. Then you continue with the matter. So then you continue the matter.
My lord. This is my instruction, my lord.
Then you continue in the matter. She's a working lady.
She's getting maintenance 15,000. Why will
So
she?
that's why settle it. If she's ready for the mutual divorce, come with the mutual divorce, settle it. One amount should be fixed, give permanent cut. Finish it off.
Lord,
What is your
can you
age?
Finally,
What is your age?
My lord,
Then
34 years.
Then it will go continue.
My lord, in the meantime, my lord,
DB Act,
Yes, my lord.
125, 498.
Just to avoid allegations, I have come before Quashing, my lord.
Okay.
Come for Quashing, my lord. Kindly
At the
pause.
Learned Council for the respective parties. This could find that. This could find that. No. For the Learned Council for the parties, let the matter appear before the next circuit bench.
Item number 39.
Yes. Who is appearing? The matter was listed on May 2024. On the said date also, none appears on behalf of the parties. Again, the matter was listed on 13th May 2024. On the said date also, none appears on behalf of either of the parties. And for the interest of justice, the case was adjourned till today. In the order dated 13th May 2024, this court made it clear that if none appears on behalf of the parties, necessary order will be passed. The petitioner has filed the present application, being present application under section 482 of the Code of Criminal Proceeding, 1973, praying for quashing of the criminal proceeding in connection with CR case number 468 of 2019, dated 25th of June 2019, under section 406/420 of the IPC, pending before the landed judicial magistrate first court at Siliguri. Full stop. The petitioner has challenged the order dated 3rd September 2019, wherein the London magistrate, considering the complaint and the statement of the witnesses, has considering the complaint, statement of the witnesses and the documents, has taken cognizance for the offense under section 420/406 of the IPC and issued summons upon the accused persons, petitioners. This court did not find any illegality in the order dated 8 September 2019, wherein the land magistrate has taken cognizance. Accordingly, the application filed by the petitioner does not have any merit. Thus, CRR number 20218 of 2023 is dismissed. Next.
In this case, can I get a copy of the item number 40, copy of the application?
For?
What about the
Things.
But 39 you said. My lords.
Yes. 40.
My lords, I am for the petitioner in this instance.
Yes.
My lords knows that section 7 of the Foreigners Act casts certain duty on the hotel keepers to maintain certain,
Diary.
my lords, in this case, what happened is, I was the assistant manager of a boutique resort in Mirik. So on the date of alleged incident, 4 foreign nationals had checked in at my resort. The day before on the day before of the alleged FIR, 4 foreign nationals had registered at my hotel. So my lords, I had informed the DIB, like my manager had informed the DIB officer through WhatsApp message, the details of the check-in of the information. My lords, I have a duty to fill Form C.
Only application. Yes, yes.
My lords, I have a duty to fill Form C. Form C. However, my lords, Order 16.6. My Foreigners Order Act, Foreigners Order 1948, 16, subpara 6, my lords.
Yes, Form C.
Yes, my lords. My lords, this can be done within 24 hours.
Correct.
There's a time limit of 24 hours.
Correct.
So, my lords, what happened in this case, that the foreign nationals entered my hotel at 16:43 hours on 31st October 2022. The police came to my resort at around 11 a.m., then around 8:30 a.m. the next day. That was before the expiry of 24 hours. They came, they see certain documents, they saw that, see certain documents, they asked for Form C. I informed them that I'm not the manager of the resort. He was on leave. So he did not know about the details of it. Regardless, they seized my article, they seized and registered an FIR against me. They seized the articles around 11:35 a.m. That is before the expiry of 24 hours. My lord, this is my simple case that before the expiry of 24 hours, they said FIR could not be registered against me. The seizure was done before the expiry of 24 hours. My lord, the seizure list is at page 31, my lords. Time is 11:45 to 11:55 hours.
Who is for the state?
I'm for the state.
Yes.
One thing is that as per the FIR, this visiting guest register was not up to date from 5th of August. 5th of August 2022. So on the basis of that, when the police visited the hotel, it was not updated. Form C was not complied with.
Yes, the date of inspection notes
On
1st November
2022 at about
And
10:45.
if you're not maintaining from August,
No, my
so
lord,
how you can take the ban and
My lord,
24 hours, that is not, as soon as not more than 24 hours.
yes, my lord, the DIB officer was informed about the same.
What?
Through WhatsApp messages that these foreign nationals have come. Their documents were sent through WhatsApp. There's difficulty of network over there. It's within a tea garden. Therefore, immediately as per he was informed. So within the duration of 24 hours, my lords. And my lords, about the hotel register, my lords, this has now that has been done, transferred into online mode, like WhatsApp on computer. That's why the book was and they were summoned under section 91. The hotel manager was summoned later on. He has
Okay,
So the intention of the legislature to
okay, you
section
face the
7
trial.
Foreigners Act,
You
my lord.
prove your all these SMS
It's related to
messages
the national
during the
interest.
trial.
It's a national interest. So
This is a simple.
Foreigners,
No case that.
foreigners, it is very difficult.
My lord, it's not that no information was given,
My
my
lord.
lords. My lord, we look at page 35, the DIB office. It's a WhatsApp
I know,
message.
madam, that's why this all the things you prove during the trial, you have sent it to inform the authority and without 24 hours. I mean, this is not a fit case. Yes, what do you want?
My lords, may then kindly.
Next circuit.
Grateful, my lords.
Let that take chance.
then we cannot raise objection in any cases, my lord. If all the cases are fixed on the next circuit.
What can be done?
Because
Such
there
and
is
so appearing for the petitioner, so and so appearing for the respondent, as per the prayer made by the counsel for the petitioner, let the matter appear before the next circuit.
Grateful, my lords.
Next.
Lord, I will put on petition.
Yes.
For the state.
I come up before your lordship for quashing the 498A.
All matter will be caused. How the magistrates will do? Every matter quashing?
498A and read with section 4 of the Dowry Prohibition Act.
Good.
Alright, in this case, charge sheet was submitted on 27th of September 2022, my lord.
What is the stage of the trial?
My lord, only charge sheet submitted. My lord, in this case, my lord, petitioner number 1 is the husband. But he is a serviceman. He used to reside Calcutta for his job. And my lord, the petitioner number 2 is the my lord mother-in-law who is aged about 60 years. But petitioner number 3 is the brother-in-law. And petitioner number 4 is the married sister-in-law residing separately, my lord. My lord, on 31st of July 2015, my lord, the petitioner had married the opposite party number 2. As per
That is correct. What is the lacuna? Why you are
lacuna, my lord.
Why you are telling
After
for the
marriage,
why you are praying for the quashing?
Yes. After initiation of the divorce case by the petitioner, my lord. Thereafter, my lord, the wife had filed this 498 case, my lord. To harass the my lord.
That is the good for you in the matrimonial suit. This is a good ground in the matrimonial suit for the cruelty.
Yes, but my lord, kindly consider the my lord, aged person of the family, my lord. My mother is 60 years. My lord, married sister, my lord, who is residing separately. My lord, they are not the my lord, principal accused. So far, as per the FIR, if I, for the sake of argument, I assume that the husband is the my lord, main, my lord, they are not the my lord. Their presence is not recorded in this case, my lord. But their my lord, presence is not recorded in this case, my lord.
Whose presence?
My lord, the other in-laws presence. Charge sheet submitted, my lord. And my lord, after the initiation of the divorce case, my lord, this
What is the allegation?
Allegation is general allegation, my lord. Physical and mental torture. She was
demand of dowry.
Demand of dowry. She was assaulted.
When she left your house?
My lord, my instruction is that, my lord, after the few days of the marriage.
Not instruction.
As per the FIR.
Because not FIR, because you have initiated the matrimonial suit. In the matrimonial suit, you might have been taken a one date of the desertion. When she has deserted.
Lord.
And you are telling that after initiation of the matrimonial case, she has initiated this FIR.
Yes.
In terms of the matrimonial suit, in the matrimonial suit, what is the date you have mentioned in the mat suit? Which date she has deserted you?
But 31st of July 2021. 2015.
2015, she deserted.
Yes. No. 3rd of August 2021.
21. And when the FIR was chalked out?
FIR was registered on my lord, 21st of August 2022.
2022.
And my lord, my divorce suit has been filed on 17 August 2022.
17th August.
Yes.
After 4 days.
After 4 days.
And what she has stated, where she is residing, since when she is residing with the father, where it in the complaint?
Well, kindly see the FIR, my lord.
Not written in Bengali.
Bengali. My lord.
I have the case diary, my lord.
That is also Bengali.
Yes.
Then what can be done?
Jane. You know the Bengali, my lord.
What I will do? Yes, as per the statement, when the victim left the house.
As per one.
When the victim left the house, matrimonial house.
Well, as per this
4th of August 2021.
4th of August 2021.
Yes, as per FIR.
As per the FIR, she left. No,
Yes.
she left.
Yes, yes, she left, she was driven out as per FIR.
As per
She was
FIR.
driven out
Ah.
and lastly on 30th of August 2022, as per allegation, when she was with her parents, all the accused persons came to her parental house and torture her. This is the allegation.
Go for trial. Go for trial.
But other in-laws, my lord, kindly.
File 317.
Then one kindly.
Not
make it
necessary.
next.
No. All matter cannot be. Yes. The so and so appearing for the petition. So and so.
But opposite party is not appearing, my lord.
Huh?
Opposite party number 2, my lord.
Not necessary. So and so appearing for the state. Full stop. The petitioner has filed the present application. Praying for present application under section 401 and 482. Filed an application under section 401.
Read with section 482, my lord.
Read with 482.
Read with
401. 401 read with section 482 of the Code of Criminal Procedure, Code of Criminal Procedure, 1973, praying for quashing of the proceeding of Alipurdwar Women Police Station, case number 67 of 2022, dated 21st August 2022, under section 498A of the IPC, read with section 4 of the Dowry Prohibition Act, 4 of Dowry Prohibition Act, corresponding to GR case number 2006 of 2022. The counsel for the petition submitted the petitioner has already initiated the matrimonial suit, and after the initiation of the matrimonial suit, the petitioner, the wife of the petitioner has filed the present complaint by implicating the petitioner as well as the old age parent of the petitioners. The counsel for the petitioner submitted since the year 2000, when she is residing separately, since the year 2000. When she is residing separately, as per your case.
My lord, after few days of the marriage, my lord.
Since after the 2 days of the marriage, she has left the matrimonial house.
Started
deciding with his parents, with her parents, and the allegation made in the FIR is totally false, and the police has not investigated the case properly. He further submits that only to defeat the case filed by the petitioner for grant of divorce, the petitioner has initiated the instant FIR. At the learned counsel, counsel for the state raised objection and submitted that as per your when she left, July 2021. She has been driven out from
4th of August 2021.
Driven out from her matrimonial house on 4th of August 2021. 2021?
Yes.
2021. And just before the 2 days of the FIR, the petitioner, along with his parents, had been to the house of the respondent, house of the de facto complainant, and have assaulted and abused the de facto complainant. At the learned counsel for the respective parties, this court find that there is no material shown by the petitioner to quash the proceeding. Accordingly, this court find that the application filed by the petitioner.
Yes, submit one thing, Marat. But as per the FIR, Marat, she left her matrimonial house as per the FIR, their statement, on 4th of August 2021. That is after 1 year of the Marat. After 1 year of the.
That's why that's in that has been recorded. That isn't recorded.
Kindly
And
state
your
it.
case is with regard to the since 2 days after the marriage. Misconceived accordingly CRR number 51 of 2023 dismissed. Next.
Number 42. Sir, take for next.
Huh?
Take for next. Sir.
Next?
Next, sir.
Why?
Here.
One dismiss, then all is next circuit. What is the case? 498A. Who is for the other side? Who is for the state? Nobody.
Shivashish Mishra is there for the state 42.
So-and-so offering for the petitioner. None appears on behalf of the state. Counsel, as per the period made by the counsel for the petition, let the matter appear before the next circuit. Next.
43.
Ah.
43, my lord, I will be in for some time.
43.
43.
Yes.
Thank you, Lordship.
Why? Who is for the?
There.
You are for the?
I'm for the state.
Who is for the petitioner?
Lordship, I am for the petitioner.
Yes.
Last order, as it is reflecting on 23/4/2024, there was no CD. So that's
But-
why that's why the matter was adjourned.
Respondent seeks accommodation to produce the CD.
Yes.
Yes.
Now,
where is the CD?
now on 10/4/2024, even state asked for time. 10/4/2024. Lordship, as we can understand that your lordship will be taking the criminal matters only one day on the next week. So practically even this year will be, and it's.
I brought one CD. Shameless death is necessary in such.
Why 2 CD?
Two cases are there.
So why you have brought 1 CD?
So I had an impression that there's one case. Later I found out that another CD will get it.
What is the case? 498.
In the morning, I have apprised you this court regarding that matter that between the in-laws 354. Subsequently, this is the first FIR 498.
Okay.
Wherein it is alleged that on 2nd November I was driven out. With the whereas I have taken my wife to the that is the case.
On the hospital.
After getting bail, my lord, they assaulted me in a roadside, my lord. Subsequently, an FIR has been lodged. Subsequently, my lord, another FIR has been lodged. He and his brother, my lord, supposedly both are the husband and his brother, my lord, assaulted me. And FIR has been lodged, my lord. Subsequently, charge sheet also been submitted. They have annexed all those documents here, my lord. They did annex the document of the 498 that which they have come before your lordship for challenging or quashing. They have not annexed any document therein. Annexed the second one cases before this court. This is in this petition, madam.
So what is your submission?
Late petitioner, sir. Late petitioner, sir.
So you have not brought the CD.
No, I am the opposite party.
Who is to brought the CD?
He is bringing the CD.
How many cases is pending between the parties?
See,
2 against you. And you have initiated one against them. No.
I have not.
They have initiated one or divorce case, my lord. So we have filed, my lord, 125 and domestic violence and this case.
This case. 4 case.
Yes, my lord, total. I have also filed a cancellation bill in the cancellation bill. About the second relating to the second torture, my lord, the second incident. I was under.
I am not understanding.
Yes, your lordship.
You are the wife.
Yes, your lordship.
Correct.
Yes, your lordship.
You have initiated an application and proceeding under DB Act.
498, my lord.
DB Act, no?
DB
125?
Yes, DB Act.
DB Act you have
yes.
initiated or not?
Yes,
yes.
What you have prayed for? What you have prayed for than the DB Act?
Rightly pointed out, lordship.
What you have
The
prayed for the
intention of the
DB Act?
legislature was like.
What you have prayed for the DB Act? Either the residence or economic support. These are the two only.
Lordship. And compensation.
Either the economic or the compensation, whatever it may be. Correct. If you are telling that, they may be sent to jail. Okay. The court will cancel the bail and they will send to jail. How you will get the benefit of the DB Act if I want to.
No, Milord, I'm not saying about the DB Act, Milord. Like in this case, Milord.
No, I am asking a general question.
Yes, Your Lordship.
I am asking a general question. You initiated the DB Act.
Yes, Your Lordship.
In the DB Act, either you have asked for the accommodation
Yes, Your
or
Lordship.
the damages by way of a maintenance.
Yes, Your Lordship. Yes,
Correct.
Yes, Your Lordship.
And subsequently, you are initiated two cases.
Yes, Your Lordship.
Two cases of 498A, whatever it may be,
Yes.
354.
And
Correct. Now you
320
file an application for
320.
cancellation of the bail.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
You are correct.
Yes, Your Lordship.
Suppose his bail is cancelled
No, no.
and he will be sent to judicial
No, Milord,
custody.
that case, Milord, I'm telling Milord. That case, Milord, I was withdrawn, Milord. Withdrawn with the impression that we are trying to settle the dispute between both the parties. Milord, so get that mutual diversion.
Yet there is no mediation center.
Lordship, the only problem is that there are actually in all cases there are different facts and circumstances. If I am being forced and if I've been forced to give something, that
No,
is the
that's-
main issue.
No, that's why I'm telling because this.
Lordship, this is very unfortunate.
I find that the
Lordship has rightly pointed out because these kind of things, Lordship, carrying on litigation for years, forcing me to bow down to certain amount, it's quite unfortunate. This cannot be permitted, Lordship. They are filing cancellation, taking it to an extent, after that withdrawing it. These kind of bargaining, Lordship, you can understand what I'm trying to say. Lordship, the date which has been mentioned.
What you are doing?
I am
Business.
like business.
What you are
Yes,
Unemployed.
he's a working lady. She is a working
Unemployed.
lady.
unemployed.
She's a working lady, Lordship.
Settle it. But your client is ready to give divorce.
Yes, Your Lordship. Yes, Your Lord. That is the reason, Milord, I have withdrawn the case also, Milord. Cancellation of bail.
What is your demand?
Milord, we are trying to talking with them, Milord. Let them, Milord, come, Milord, with
Sit together.
Yes, Your Lordship.
Lordship, my instruction is that after this has happened, the series of litigations, I can advise my client anyway.
See, this
That
will
is-
continue. This will continue.
Lordship.
The professional, this will continue. No
Lordship.
problem.
Lordship.
To do some social work.
Lordship, we are always ready. We are always
Do some
ready.
social work.
Lordship, probation was, I also
Now,
offered him.
this is the fashion now.
Yes, Your Lordship.
Lordship,
This is the
but
fashion now.
but
498A DB Act 125, this and
Lordship,
that.
Lordship,
And then husband
Lordship,
goes
but
for the divorce, then
Yes,
it
Your
will. And you knows with regard to divorce, there will be a demand.
Lordship,
So you settle it. If it is not settled,
Lordship, even Lordship, I'm humbly submitting before your Lordship that even if this FIR, if from the contents of this FIR, if it is seen that the day when she is alleging that I tried to kill her by strangulating another, at that point of time I've taken her to the ear, and if this FIR do not stand today as on today, then it will be a ground for me
correct,
for the divorce.
FIR is
Now,
not a-
Lordship,
that's why
Lordship,
initially I told this is a professional. You leave it to
Lordship,
professional.
please appreciate. Now, Lordship, from this FIR and that FIR which I have argued in the morning, and from the conduct, what you can understand, Lordship, I can be that certain pressure is being created upon me, and whether at this stage I can go down to that or not, that is the main thing, Lordship.
And what has happened? The first matter, what has the morning?
First matter morning, I have apprised this court and I have not pressed for stay. That has been fixed on 21st.
Let it be come along with it.
Come along with that.
No, with that matter. With the matter.
Along with that.
I don't have them, Milord, copy, Milord. I don't know, Milord.
Today's item number 20. 20 and
Milord, I was not given any copy, Milord.
What?
That copy,
will be
Milord.
served, don't worry. That will be served. There's a
So
direction
and so,
for-
so and so appearing for the petition, so and so, so and so appearing for the state, and so and so appearing for the opposite party. The counsel for the petition submit that the analogous matter is appearing on 21st of May 2024. Let this matter be appear on 21st of May 2024.
Let the copy be.
What is the number along with CRR number? Item number? Along with CRR number 173 of 2024.
Milord, let the copy be served, Milord. I will not serve the.
Already there is a direct.
Yes, sir.
Next.
I don't know what it is. I have the petition. But it's actually Quashing or Quashing is not before. I serve.
What is the section?
I just press it.
468, 419.
So this is case under 490, 420 and 468. But my point is that if the allegations are accepted, the case under 490 and 420 will not come. Even the allegations are accepted. Secondly, we have to say to 468. The allegations are improbable because he is a third party. He said documents are forged. The document may possess cannot say. I feel the tax part. So tax of the petitioner, complainant, and other two persons, other partners of business. They enter into an agreement with Babulal Agoran, Jugal Kishore Agrawal for their board. There is one company for personal one that because of land in Jammu. And they jointly, even the complainant also paid the money to them. These are disputed. These are some land regarding transfer of the land problem. My partner saw the complaint against me. You see the complaint. Then read the complaint. Do not make any case. And it's place of certificate of the
Which FIR?
only a from the if you got it, I guess please. I see Kamal Sharma. Sharma, date to state Kalana. On 28th February 2015, there was an agreement of purchase of 135 acre land. We can see Ramesh Marwal, the petitioner, the Kamal Sharma, the complainant, and two other persons as purchaser jointly served from a private limited company. A name of Dineshwar Real Estate. This is not from Guwahati money. A seller represented by his two directors, namely Babulal Agrawal and Jugal Kishore Agrawal, both residents of Guwahati. Purchase price of said land was agreed between the parties rupees 2 crores confirmed. On the date of signing the said purchase agreement, we as purchaser have jointly and severally paid the directors of said private limited company out of our own respective sources the amount of rupees 20 lakhs on 28th February 2015. Therefore, with the purchasers have further paid a sum 1/4 something to the gas directors of say private limited company on several days. Thus, the total amount of 1/4 to 40 lakhs are paid to the seller jointly and severally by us purchasers. My contribution in the state table purchase amount of rupees 35 lakhs. The state land was the Rajman. So this Ramesh Agrawal has been looking up the state land on behalf of the purchaser. We did not pay the balance amount to seller till then. Hence, this was no registration of the land by the seller company in favor of the any out of purchase. So there was some dispute between us purchasers. There is dispute among themselves. Sometimes in the beginning of year 2020, since then Ramesh Agrawal has been keeping himself aloof from us, particularly from me, the Kamal Sharma. The lab things that any board meeting of the seller company had not been held for a long period of time, particularly on 10 February 22, at any place, Sri Ramesh Agrawal for his illegal gain and personal benefit has manufactured document 10 February 20 when he has been placed upon the right of the seller company with immediate effect. There is no such meeting was actually held. It cannot infer that document dated is a manufactured document. The Ramesh Kumar Agrawal had also forged the signature of the stamp present on the document in the name of seller company of Dineshwar Real Estate. See, Ramesh Kumar Agrawal has also manufactured document dated wherein he has alleged given power to the execute and sign documents on behalf of the seller company. Dineshwar, this was done by Ramesh Kumar Agrawal with the intention of getting the properties and money about the seller company as well as the money invested by me as a mentioned above, not me. Ramesh Kumar Agrawal has used this manufacture document to enter into various sale agreement, the name of the seller company. They were falsely represented before the ADS or Rajgon Jalpaiguri as director of the same company. He was also not given any such powers in the agreement dated as mentioned above. That on my demand, for my share of profit, the money invested by me, the Ramesh has been denying, not giving extraction for non-settlement. It is clear that he has grabbed my hard money for his personal benefit. So he was the first. We are the complainant, myself, and the two persons. We are the joint company. We paid 1/4 because he said, join you have paid, and he have paid $30 to the company of body for the seller. Now, there's some dispute. He himself said there's some dispute with purchasers with the sellers. Now he said, I made a document on behalf of the seller company. I became the dealer, but until the company has made any complaint that whether I've been included, I being one of the purchasers, included the company as a director or not, or any document has been manufactured by me, who will say that complainant is a third party. So there is no, he has never said, I have cheated the money. He himself said we jointly paid the money to the seller. There are some disputes. He may be withdrawn himself. But this is not the way, because he has not said that he paid the money to me. He said we jointly paid. And out of the 1.4 lakh, he paid 35 lakhs. But he said, why I will not bring the money from them? That I can't do. But what the case of cheating, there is no intention when this agreement was executed or the deal has been done. There in the intention, there is no question of cheating. He said, yes, we paid jointly on several various occasions. He also paid 35 lakhs rupees. Now he said in two ways. He said, I did not take steps to settle the matter or return his money. And on this, he said that I made a force of, if I suppose I am not the director of the company.
Correct.
Who will say? Third person will say. The company, the government should come and say, yes, this person is not the director of our company. This document is forced. How will it say?
But the paragraph 4, the board meeting of the seller company of Jineshwar Real Estate Private Limited has not been held for a long time. Correct.
How will it say? How will it say? The company of what?
So, but see, it is not necessary. If it is not necessary, who will be the complainant? If a complaint has been received, it is the duty of the police to investigate. It is not necessary the person affected.
Yeah, yes, that can do. Suppose there is a case of some rape or something. Here, he said, this is a company, name of the two directors, they are the sellers, there's a transaction. Suppose seller, he came to know from the sellers that I made this document. Seller has not come. The company directors have not come. Company has not come. What's the allegation? I posed myself as the director of the company. He said there is no meeting of the company of this company, how he has been director. So document is manufactured. Inference he has done. But who will suppose seller he has got no document to sell it.
Correct.
He said yes, that yes, no, there is no meeting of the company. We have not made him the director. Then my third party in 460 document management appreciate first cheating, first forgery, then cheating. How he said is a court of suppose if I produce a document, how the third party can say?
So let the police investigate.
But you also involved, but you also can see the seller will not say anything.
That's why the police, let the police, what is the stage of the investigation?
It's going on, my lord. The investigation is going on. His anticipatory bail was rejected by a division bench of this honorable court. He was served with a 41A notice. He did not respond to the notice, my lord. There is no cooperation from the end of the accused person in the investigation. The investigation is going on. My lord, whatever my learned friend has submitted, but if if, for example, if that is accepted as true, my lord, then the argument itself is contradictory, because, my lord, the allegation is that these person, the accused person, along with the complainant and few other persons, they formed a group. There was an agreement between them and the company. Now, my lord, what happened thereafter, as per the complaint, that this person, the accused person, the entire transaction happened on the basis of an agreement. He showed that the company is a different entity and he is one of the person from the group of purchasers. But subsequently, when the money was paid, my lord, it came to the light of the complainant that this person impersonating himself as a director
of the company.
My lord, he has done the entire deal, my lord, keeping every person, all the entities in dark. So, my lord, his presence and his cooperation in the investigation is necessary, my lord.
So no, it's still just been not arrested?
No, he's absconding, my lord. Repeated raids have been conducted.
What he said. First of the complaint, he admitted that we are the 4 persons. We are the purchasers, jointly purchasers. We paid money 1.40 lakhs. I also paid. He did not say that I did not pay. We have said totally 1.40 lakhs. And to the seller, he not said he paid the money, I paid the seller. He said we jointly paid and his share is 35 lakhs.
Okay.
Then he said there's a dispute between us.
Yes.
The partner.
Correct.
Now he said I should get back the money or settle the land. And on that score, on that span, he said, yeah, I produce a document which is manufactured of the sellers. And the seller company, I become the director of the seller company. He suppose I'm here, I am particular.
So that's why see, he has raised some point on the documents which you have relied upon. Correct. And that document, whatever it may be.
He said it's the document.
Correct.
I'm not the director.
So let the document investigation.
They said I'm actually. They can go to Guwahati and Guwahati complain that suppose the directors are complaining there, the sellers. They can say whether they have given the document or not, that I'm a director or not. So only even suppose I'm actually I'm not arrested. What the investigator said, it was to appreciate. Anybody else come and say, yes, I'm first the director of this company. The company, they should take it. I don't suppose the director of the company said, yes, he is not my director, I have never made him director, the document is false. Then I have nothing to say. Just going to appreciate this.
Yeah.
Last occasion, High Court was director put in the police records. I see the city, is there any investigation at Guwahati?
What are the CD? Yes.
If Guwahati people say yes, this is false, then I have nothing to say.
Lord, the page number 42 is the 161 statement.
42.
42 and 43.
Hmm.
Lord, which shows the implication of the accused person, the petitioner.
41.
42 and 43, my lord.
What's the name?
Shyam Agarwal and Pawan.
What did who's the directors?
Yes.
Shyam is one of the purchasers.
Shyam Agarwal
He's one of the purchasers, not the director.
and Pavan Agarwal.
There are 4 persons.
Yes.
But I read that the director, the company, only I mentioned that I forged the document of the purchasers, sellers company.
Okay. Yes, what are the material further? What has done to where is this incremented 2 documents have you seized? In the FIR,
My lord.
kindly come to the FIR.
Yes, my lord, one agreement has been seized. That is in page 32.
Not agreement.
My lord.
Illegal gain for the personal benefit, manufactured a document dated 10/2/2020. What is the document 10/2/2020?
My lord.
Wherein he was allegedly appointed as the director of the seller company.
I only read the statement of sellers directors. The directors, yes, these 4 that I am.
Correct.
No, my lord, the agreement has been seized only.
Where is the document of 10-2?
But that is
That
not
is the
in-
main agreement, two documents. 10
That
to
is not in the
2020,
lord-
10 to 2020, that is the minutes of the meeting.
lordship.
And there in the agreement is 14 to 2020. Manufacture the document of power of attorney.
My lord.
14 to 2020.
My
What
lord,
has been done?
it is not, my lord, as per the memorandum it is not seized. But my lord, I am holding the certified case diary, my lord. So,
When the last CD? What is the last date of the CD?
Lord, it is 21st of May 2023.
Thereafter there is no. You are not coming with the proper case diary before the court.
My lord, in revisional applications, usually the certified case diaries are sent.
35 2023. Now we have 1 year has been passed.
Yes.
This is the 21st May 2020. That is the date of FIR, sir.
No, sorry. I'm sorry, my lord. I'm sorry. It's 9th of February 2024. I'm sorry.
9th of February 2024.
Yes.
So with regard to the FIR paragraph 4 and paragraph 5,
My
what about this document?
My lord, except this document, my lord, there is no document seized in this CD. My lord, let the original case diary, my lord.
Call for.
Lordship.
Well, I need the state.
My lord, at the same time, my lord.
No. Your bail was rejected by the
Yes.
division bench. How this court can
Lord,
give
it
the
is-
stay?
No, I'm not going to that. Your lordship is rejected. When I move, I did not get the stay. Court, all I could say, you mean? So the copy of I served. Now it is at the final stage. Because I'm not. I know
That's
that-
why I mean, if the CD is there, I could have been heard hearing now. There's no problem.
There's a- sorry, he said that this was opposite manufacturer. Who of the part of the Sinner company. The Sinner was director given 161.
So that's why I want to see whether that's why I want, because the complainant has given 2 dates. 14 to 2020, 10 to 2020, there are 2 documents. Power of attorney and this meeting. These 2 documents, whether it has been seized, from whom it has been seized. And it has been seized, whether it has been sent to the CFSL, what is the result of that? These are the 2 things.
This document I got it from the seller, the 2 directors. One of them was only 161 years. And I then
So and so appearing for the petition, so and so appearing for the state respondent. Full stop. The counsel for the state respondent prays for time to place the case diary. Let the matter appear before the next circuit. Which PS?
My lord, Rajganj. Rajganj PS.
Up and down.
On 21st.
Wait for me. Oh, appear at the moment. Yes.
সোমবার দিনকে WPA করবে?
মানে রিটেড হিয়ারিং গুলো রিট ধরবে
আমি একা মানুষ সাইডের মধ্যে পাঁচটা লোক মোটর চালায় আমাকে একা তোমাকে দিয়ে তো আমি রেকর্ড করতে পারবো না তুমি তোমার কাজ করবে এটা দেখো আমার এটা আজকে মাত্র এই এক্সপেরিয়েন্স 3 দিন ফুল চালাচ্ছি 3 দিন
देखिए हम आप लोग के लिंक रखते हैं कितना का लिखा हुआ है आपको दे दिया है कहीं कहाँ गया था ये दूसरा दिवस लीजिए मैं सब लीजिए ताकि देखें कि यहाँ रखे रुका नहीं वो तो दिए ना यहाँ पर होता क्या जैसे इन लोगों का सामने है ना मालूम हो जाएगा आपके इसीलिए थोड़े नहीं है लेकिन ये तो पास तरह दिक्कत हो ऐसा तो हम फेंक देते हैं इसको जाने से पहले फिर मुझे बात करना पड़ता है ना हाँ ये बात है बाकी आदमी अच्छा है ये इतना ये नहीं करेगा খাওয়ালি তুমি খাইয়ে সেগুলো আমার হাতে আমি যখন খাই আমি খাবো কিন্তু বাচ্চাকে নিয়ে সেগুলো খুব দরকারি বাচ্চাদের স্কুলকে রাখতে যায় কালকে বলছো পরশু দিনকে বলছি ওই দিন আজকে যে অ্যাকশন নিই তো কালকে আবার 11:30 বাজে বললো আমি মা ছিল শুয়েছিল জাগলাই ছিল কেমন শুরু না তুমি যাও তুমি খাই যাই তুমি আমার হাতে রাখবে আমি ছাদের থেকে মোটামুটি 12:30 কোনো একটা দিকে নামছি নাইমার পরে দিয়ে কোনো ভাব করা তুমি দেখি চাপ আছে আমি কি হলো ভাব মানে ওরা ওটা আবার দিচ্ছি না দিচ্ছি আমাকে বললাম যত ভালো হবে আমার বাড়ি এখানে বাইরে তুমি আমার সাথে পাল্লা করো তারপর তুমি বলবে আমার জীবনে একটা সারাদিন আমি কাজ করতে পারি কথা করতে হবে না কিছু 11:30 হবে না তখন আমি সামনে আসছি ঘরে গেলে বসে ভাত করে কথা বলি ভাত খেতে খেতে বাজে 12:30 বুঝলে বাচ্চা নিয়ে আমাকে ঘরে বসে থাকতে হবে স্নানই করলাম সারাক্ষণ কাজ করতে করে 11টার সময় বাড়ি থেকে স্নান করে তখন সাথে সাথে ভাত চলে যায় ও বাচ্চা থেকে জানলা থেকে বসে থাকে ইচ্ছা না কোথায় ওষুধ দিনের বেলা কিন্তু দুবেলা যে আমার কাজ করতে দেরি হয় আমার জন্য বসে থাকেন বসে থাকে তা তো দিনের বেলা বসে থাকে যেমন আসলে বাড়িতে আছে বসে থাকি খায় না পেছনে দাম করতে এগুলো জানো এগুলো রাত্রে কথা বললো তারপর ওষুধ হয়ে গেল যখন এমন সব কথা বলে দুটো কথা না বললো না তো বললাম একটা বাজে খাইতে হবে না তুমি না খেয়ে দেখো তুমি যদি খাইতে যেতে তুমি খাই এসে তুমি মানে আগে শোধ লোককে অ্যানাউন্স না করলে হবে